Under compelling circumstances, my
No
lord.
mentioning.
My lord,
Only one.
my lord, kindly appreciate. My lord, kindly appreciate.
Right.
My lord, these petitioners, my lord, extreme urgency, my lord, these petitioners were appointed pursuant to orders of the Honorable Supreme Court back to their own ground in the primary sections. And till 31st December, my lord, they were to be appointed. And now the Honorable Supreme Court has extended such time to 31st August. But we have been we have been saddled with the orders that we have to join within 31st. My lord, they are working in their respective schools in the under the School Service Commission's guidelines, my lord, and the Supreme Court's order. We were praying for extension of their tenure to be for before joining the primary schools, my lord. But 31st, my Supreme Court, Honorable Supreme Court have
Mentioned before the Honorable Supreme Court that this has not been complied with.
But Honorable Supreme Court has already extended the time, my lord.
Mentioned before that court that this notification has been given by this court.
No notification, my lord. We have.
Yes.
My lord, upon service notice to the opposite party, my lord, it is a transfer matter, my lord. The petitioner resides in 84 kilometers from the service school, my lord. If you lordship kindly be fixed on January in any day.
After the vacation.
518 of today's list. Commitment, video of the deceased teachers, my lord, being old aged.
We'll take it up. Serially, we'll take it up after the vacation.
Lordship,
We'll take it up. Serially, we'll take it up. Don't worry. After the vacation.
Last Tuesday, my lord, your lordship was taken up a matter much regarding revert back to the post of my lord.
Not now.
My lord, notification issued on the 18th of December stating that.
Not now. After the vacation.
It will take only 1 minute, not even less than 1 minute.
After the vacation, you mentioned.
My lord, I'm for the petitioner led by Mr. Shamna.
But I beg to appear on behalf of the respondent primary school council. My lord, at the outset, my lord, I raised the point of maintainability with regard to this writ petition.
Okay. That's it. Very good. What is the can?
Well, there is no can.
There is a can.
At least, my lord, not by the.
Who has filed this? Apurvo Karmokar?
This is the petitioner. There can to file with petition. My lord, probably this was filed earlier. I think this has no consequences, my lord.
Okay. Yes.
No.
Before my learned senior friend proceeds is the matter, my lord. I raise the point of maintainability of this writ petition.
Yes.
Because this writ petition, which has, my lord, now become infructuous, my lord, is sought to be improved by filing a supplementary affidavit. If your lordship kindly looks at the prayer in the writ petition.
Yes.
At page 34, there is only one mandamus sought. That is the respondent number 4 and 5, their main agents, successors, and each of them to publish the approved panels for different categories and to issue letters of appointment in favor of the impaneled candidates, including the petitioners forthwith. Number one, what has happened in this matter? This is with regard to the 2009 selection process. Number 2009 selection process has seen lot of topsy-turvies in this world, my lord. Challenges were made, examinations were stalled, de novo selection written test was held, interview was held. Subsequently, by traveling through the Honorable Supreme Court in 2021, my Lord Justice Chakraborty, Honorable Justice Tabodha Chakraborty was pleased to pass the judgment that in 2021 that you published the panel. So their grievance with regard to publication of panel and issue of appointment letter was merged with that judgment, because in compliance of that particular judgment, my Lord, we published the panel and issued appointment letters. They were unsuccessful in that recruitment process. Their names did not feature in that panel. So their grievance as regards this writ petition is over. After this, what has happened? There were several other writ petitions. Some writ petitioners, my lord, had challenged that there are some vacancies left. So we should have been accommodated in those vacancies. They filed fresh writ petitions before this honorable court. In 2024, my lord, those writ petitions, my lord, this is the long and short of the story. Then I will take your lordship to the entire writ petition, the supplementary affidavit.
Yes, carry on.
Now, this is a 2019 writ petition. Inter alia seeking the relief of publication of panel and issue of appointment letter.
Panel published.
2019, they were seeking publication of panel, and the panel has been published in 2021. Appointment letters have been issued. Well, that is the judgment of Honorable Justice Chakraborty, which is not annexed, which could not have been annexed in 2019, because that was a subsequent development in 2021. They have taken out a supplementary affidavit. In that supplementary affidavit, they have not annexed that particular judgment of Justice Chakraborty.
This is passed in
2021, 8th of January 2021. So this is the judgment. 8th of January 2021. Now, if your lordship looks at, this is elaborate judgment. If your lordship looks at paragraph, what the number paragraph? 41. One page. Well, lordship may kindly takes paragraph 36, page 36, paragraph 40 of that judgment. Judgment copy ta dena Shubidar ke.
না না দরকার নেই
না মুখস্থ আছে Shubidar মুখস্থ আছে রাফে আছে দাদা. Accordingly, this court, has your lordship got that? Accordingly, this court directs the North 24 Parganas DPSC and Malda DPSC. My lord, we are the Malda DPSC and Malda DPSC to publish the panels as provisionally approved with a memorandum dated 11 June 2015, 17 June 2015 in the respective websites within a period of 2 weeks from the date of communication of this order. Well, this is also relevant, my lord, paragraph 41, because they are harping upon this. Vacancies arise every year due to retirement, resignation, removal or dismissal, death of appointees. The 2001 rules also provide for sanction of additional posts of primary teachers due to increase in role strength in primary schools of the districts or the subdivision. Having regard to the peculiar facts and circumstances that have emerged, and as the respondents are to be blamed for having denied appointment to the candidates impaneled, they must take necessary steps and ensure that the impaneled candidates are appointed in the existing vacancies and in the vacancies arising in immediate future. The respondents, including the state respondents, shall also take steps towards creation of new posts, that is supernumerary posts, to accommodate and appoint the impaneled candidates. Those who are impaneled, if there is no vacancy, you create a supernumerary post. So whoever has come out successful into a non-successful process, you give them appointment. Normally, in compliance of this order, judgment and order dated 8th January 2021, in Nihar Bishwas's case, my lord, the panel was made, appointment letters were issued, they did nothing. Now, my lord, in 2024, some persons who had participated in the selection process, they may or may not have been called for interview. They filed certain writ petitions before this honorable court. They said that though we participated in the selection process, but still we have not been given appointment. They filed fresh writ petitions. Now, my lord, those writ petitions came up for consideration before my lord Justice Mantha, my lord. It is annexed in the supplementary affidavit. My lord, they are not trying to bring out a new cause of action. What I have learned from my Mr. Shanal, my lord, this gives rise to a new cause of action, because after this prayer in the writ petition that you publish the panel, issue appointment letters, which is now over, a new cause of action arisen after the order passed by my lord Justice Mantha. my lord, which is appearing at page 19 of the supplementary affidavit.
Yes.
My lord, this is a big judgment and order. I'll take you, not trouble your lordship. This is appearing from page 19. Your lordship kindly turns to page 23. Paragraph 13, my lord. In the above circumstances, following the order dated so and so, for the reasons stated there in respect of the DPSC Howrah, this court, by consent of all the parties, is inclined to direct that all candidates who were called for interview in the aforesaid recruitment process of the year 2009 and have filed writ petitions until 25th April 2024 shall be entitled to appointments against existing or future vacancies. Those who participate in the selection process, who were called for interview and have filed writ petitions, my lord, they will be entitled to get job. Now, my lords, several water flew through the Thames, my lord, after this. This order was passed basically by consent of the parties. By consent of the parties, which was
Yes.
well, this was controverted, my lord, by the DPSC and the state, that we had not given any consent.
Where it is written, where it is written, it is consent given
My lord, your lordship kindly sees.
by consent of the parties.
Yeah, has your lordship got that? Yes, I'm grateful to your lordship. Now, after this, my lord, what has happened? The state and the DPSC, my lord.
So this order, para 13, in respect of DPSC Howrah only.
No, this was following DPSC Howrah. This is with regard to DPSC Malda. If your lordship now looks, my lord, it will be clear. Paragraph 16, 15, 16. The DPSC North Malda and the
This order
Saurabh Naskar order was
13, para 13.
paragraph 13.
It relates to DPSC Howrah.
My lord, paragraph 13, I'll tell you, lordship. Saurabh Naskar and others versus state was with regard to DPSC Howrah.
Yes.
So following the same line, in the same line. So following that DPSC Howrah orders, this is with regard to DPSC Malda's writ petition. That is why they have annexed it in the supplementary affidavit. Saurabh Naskar was the first of such writ petition.
Okay.
Which was passed on 9th April 2024. Just few days thereafter, on 26th April 2024, this order was passed. Has your lordship got that, my lord?
Yes.
Because if your lordship kindly, this will make clear. Paragraph 11, paragraph 15, everything. 11 says it cannot be said that there were no irregularities and inapproprieties in the recruitment process to the post of assistant teachers completed in the year 2021 in the DPSC Malda. Then again, my lord, paragraph 15 also, the DPSC North Malda and the state. 16 also DPSC Malda. So this is with regard to Malda, my district. Now, my lord, what has happened after this, my lord? The state, the DPSC, they challenged this order that we had not given any consent. The Honorable Division Bench was pleased to dismiss that appeal, that whether you have given the consent or not, you go and agitate this point before the Honorable Single Judge. The state and the DPSC, they filed a review application before the Honorable Single Judge. The Honorable Single Judge, my lord, recalled his order, saying, my lord was very perturbed by the fact that you had once given consent, but thereafter you are withdrawing the order. Kon page ache? Recall kar? Huh? Page 45. Recall that order. Now, my lord, assailing this order, lordship may kindly see page 45. Start from page 45, page 47. Paragraph 6. Be that as it may, since the orders, lordship got that, since the orders have been passed on consent and such consent has never been given in writing or given and withdrawn, this court is inclined to recall the order dated 26th April 2024.
Yes.
Your Lordship got that, my lord? My lord, assailing this order, some of the writ petitioner, my lord, went up before the Honorable Supreme Court, which is appearing at page 48. The Honorable Supreme Court, my lord, is subject to correction, was pleased to set aside the order passed by the Honorable Single Judge in the review application. And therefore, the order passed in the writ petition, my lord, revives. The order revives. Now, my lord, all these persons came up before this Honorable Court that in spite of the admission of the SLP or the order passed in the SLP, the consuls are not issuing appointment letters. Several contempt applications were filed. The consul started issuing appointment letters to all these persons. So they got appointment. These persons got appointment.
Okay.
But on separate writ petitions filed in 2022, 23, 24, these persons got appointment because their prayers in the writ petition was with regard to the fact that still there are vacancies, we should be given appointment. Now, my lord, a cutoff date was fixed by the Honorable Single Judge. Your Lordship has seen that.
Yes.
A cutoff date was fixed by the Honorable Single Judge. That is 25th April 2024. Now, my lord, even after cutoff date, some writ petitioners preferred some separate writ petitions. They also got appointment because they were also pursuing their case. They filed a separate writ petitions. The Honorable Single Judge, well, there was some contempt applications filed by them. So, on the threat of contempt, we have given them appointment. Now, my lord, my contention, my lord, subject to correction by your lordship, they had filed separate writ petitions stating that there are vacancies, praying that in spite of there being vacancies, they had participated in the interview, they be given appointment. Now, my lord, this writ petition has outlived. My lord, today this writ petition is on the ground that their panel is not being published. Appointment letters have not been issued. Panel has been published. 2021 appointment letters were issued. Now, my lord, if at all, my lord, I said they do not have any cause of action, but if at all they have any cause of action, that ought to be, my lord, by way of a separate writ petition, not by way of filing supplementary affidavit. This is elementary, my lord. If a new cause of action is generated today, there has to be a separate writ petition. This is one aspect of the matter. Now, my lord, in this writ petition,
Yes. Yes.
but in this writ petition, there are 17 writ petitioners. My lord, at that point of time, since the panel was not published, subsequently panel was published. Out of the 17 writ petitioners, 3 writ petitioners came out with flying colors. Their name was impaneled and they got the appointment. So their names ought to have been expunged. Subject to correction, their names have not been expunged. That is writ petitioner number 6, 3, 6 and 11.
They have been given appointment.
They have been given appointment. Huh? They are because their names were impaneled. আচ্ছা এর অসদিনের সঙ্গে এরা ছিল না Now, my lord, another set of writ petitioners, other 3 set of writ petitioners, writ petitioner number 8, 9 and 15. My lord, they had filed separate writ petitions as in those cases where Honorable Justice Mantha was pleased to direct them to give appointment. They had filed separate writ petitions even after 2019 writ petitions.
8, 9 and 15.
8, 9 and 15. And they have been given appointments. Their names have not.
Petitions have been disposed of.
Those writ petitions have been disposed. My lord, Justice Mantha's writ petition has been disposed of.
What is the order passed? They have been given appointment.
They be given appointment. 25th April 2024 was the cutoff date. So they had joined hands in those writ petitions.
Oh.
So they were given appointment. So out of 17, my lord, we are now left with 11. Now, one of such writ petitioners, the responding petition number koto? This is writ petition number 7. has sent letters to the learned, to the DPSC as well as to the learned advocate, I believe, saying that, but we have also informed the learned advocate on record, my lord. Yesterday, my juniors informed the learned advocate on record that I have received such letter. This was addressed to the bar and this was addressed to the DPLC also, that without taking any no objection from me, it's fact ache. His name should have been expunged.
এটা দিয়ে দিন।
Name automatically expense, they do not proceed.
Yes.
Without taking any no objection from my erstwhile advocate, my lord, and I have not given any authorization to the present learned advocate, my lord, he is proceeding with the matter. Writ petition number 7.
সারা দিনই চলে। চালাবে না। ঠিক আছে, বলবে কেন? তো এবার দিতে চাইছে, সবসময় চাচ্ছে, দিয়ে দেবে।
Who is Apurva Karmakar?
Well, he is the writ petition number 1. He is the writ petition number 1.
And this applicant
This
Sujata Das?
writ petition number 7. 7 to Sujata Das. 17. I'm sorry, my lord, is writ petition number 17. 17. Look, these facts ought to have been disclosed in the supplementary affidavit that 3 candidates have already been impaneled. 3 candidates have subsequently got the job by filing separate writ petitions in 2024. Now, my lord, lordship comes to the writ petition number 1, that is Apurva Karmakar. But completely misleading and which goes to the root of the matter. Because if the petitioners have come to the court with unclean hands, my lord, the writ petition is liable to be dismissed. The lordship is not supposed to go to the merit also. That is the judgment of the Honorable Supreme Court. My lord, Apurva Karmakar, the first writ petition, lordship kindly sees page number 1 of the writ petition. Very cleverly, very deceptively has mentioned the name of his mother in the writ petition. The first page
of the writ petition.
of the writ petition.
Cause title?
Cause title, my lord. I'm grateful. My lord, Apurva Karmakar, son of Aruna Karmakar. Lordship got that?
Yes.
That's the name of his mother. Now, my lord, what he has, yes, why he has done so? What was the reason? Because page 41, the authorities will not be, page 41 is his admit card. Page 41 is his admit card. Aruna Karmakar is the name of his mother and father's name is Deepankar Karmakar. Has your lordship got that?
Yes.
Right. That is why he has not mentioned the name of his father, because he has filed a subsequent writ petition 2024 and without even disclosing that in 2019 a writ petition is pending and is seeking a job. His respondent is petitioner number 29 at page 7. Fresh writ petition করেছে. Without even disclosing. And this fact is not disclosed in the supplementary affidavit also. That Apurva Karmakar has filed a writ petition 2024. Lordship, may kindly see the name of fathers come now. Mother's name doesn't come. Son of Deepankar Karmakar. Father's son, mother's son. ওটাই তো বললাম। This supplementary affidavit has been affirmed on subject to correction on 5th of August 2025. That writ petition was filed in 2024. By that time, 6 candidates have already been given appointment. চারজন, তিনজন,
কজন টোটাল কজন আছে এখানে?
17 জন।
হ্যাঁ, বলেছি 10, একজন তো আসছে।
Yes.
Now, my lord, this is, my lord, today
Cost.
my lord, my learned senior friend is very enthusiastic. He's taking cost and everything. But today, my lord, this is mockery of judiciary because, my lord, we have been told if there is change in the cause of action, we have to file a separate writ petition or a plaint.
Yes.
Well, the cause of action today is no more there. He has a new cause of action saying that by virtue of an RTI application, he has come to know that there are certain vacancies which are still to be filled, which, my lord, in my humble submissions through this writ petition, my lord, it is not, my lord. It cannot be assailed in this writ petition, my lord.
Yes.
But with regard to merits, I have other things to say, but this is with regard to maintainability. But they are not entitled to this job, my lord. I'll come to that also. But this is with regard to maintainability. This is not maintainable. Even they have not tried to make an amendment application. But by filing a supplementary affidavit, they are trying to ventilate a new cause of action.
Yeah.
And the fact with regard to, my lord, coming to the court with honorable, with the unclean hands, my lord, that is also there.
My lord, when on the last occasion I submitted before your lordships the supplementary affidavit. My lord, there are 2 supplementary affidavits. One I submitted before the court, the other not yet. But both were served upon them. Both. No, bolo na. Both copies have been served. And your lordships kindly recollect, I never had resorted to any fraudulent practice to the court, even appearing for a counsel of any of the petitioners. I mentioned that, your lordships, that there are 17 writ petitions, your lordships kindly recollected. Out of them, 7 have already got appointed. Those are the presidents. 7 have already got appointed. 1 is not inclined to come up, and 9 is there. Malad, they are all, Malad, the poor boys of the village. They are asking for the appointment. Now, what is the situation? I just tell you, lordships.
In
Now
which paragraph you have stated that 7 has got appointment?
Nowhere.
That's your lordships, my lord. Your lordships, if your lordship allow me, this copy has been served long back.
No. We have not received any copy. My lord says we have not received any copy.
All right, let's see. No, দেখাও তো serve করেছো।
ও তাহলে ভুল কথা বলবে না ও। He has in fact informed over phone that I am getting such letters. Thereafter, my lord, this supplementary affidavit would have been affirmed. And I never said that my learned senior friend practices fraud, but his clients practice.
Any, my lord, all that, your lordships, the affidavit, supplementary affidavit that has been affirmed on, which was filed before your lordships, that's affirmed on 5th of August,
Right.
if I'm not wrong. That's
5th
correct. The another affidavit, according to my junior, that has been served, but they are saying not. That's also served on 8th August 2025. Both of them.
We have not received. We have not received that affidavit.
This has been disclosed by them. I'm giving that, your lordship. There is no suppression as such. I tell your lordships. Naturally, those who have got appointment, they never want to come before the lawyers. There are several consequences. Those are practical things. I'm not. That I have disclosed to your lordship. I will take your lordships to the subsequently to these facts. These are them, I will take your lordships to this affidavit. But I take your lordships first. What is the matter before your lordships? And how far this council has gone to the extent of issuing appointment letters, even those who have not been interviewed even. I will show to that. So they are so, my lord, flexible because of their illegalities. All the 4 councils, Howrah, North 24 Parganas, South 24 Parganas, and Malda.
But Malda, it has been stated that there is no irregularities.
And so, your lordships, then why they have accepted it? The court's order.
In Malda, the original order of 26th April records that there is no irregularity in the.
I will take your losses.
That is, my lord,
I will
this
take-
Manta's first order.
I will take your
My
losses.
lord, this Manta said that even if they have appeared for the interview, give them job. Even if they are not, my lord, coming in the.
I will take your losses one by one.
What I'm asking him is on 26th April,
Right.
while on consent an order was passed,
Right.
that those who have appeared in interview and they have filed their writ petition within 25th of April, they should be given it. Now, we are on that order because it has gone up to Supreme Court.
Right.
Review that has been restored. The order has been restored.
Right.
Correct? In that order, in paragraph number 11,
Ah.
it says that there is no irregularity so far as DPSC Malda is concerned.
No. My lord,
May
that
I take your
paragraph.
losses too? Then your losses.
No, just clarify then, my lord. Paragraph 11, Asuddin's order. But it has been said it cannot.
Cannot.
Be,
Okay.
it cannot be.
Yes, yes, yes.
So there were irregularities. I'd say that.
Yes, yes.
And,
Continue.
and in fact, my lord, what has happened, my lord, I have even after this order, I have given, my lord, I was telling that I have given, my lord, appointments to some candidates, which is appearing, my lord, at page 51, my lord, if you lordship kindly sees page 68. They have issued appointment. They have issued appointment. Page 68 is the order. They had filed.
This is DPSC Malda.
DPSC Malda. They had filed writ petition even after 25th of April. Paragraph 3, my lord, filed on 3rd of May 2024. I have issued appointment letters, my lord, on the threat of contempt at page 70.
Okay.
And my lord, if you lordship
Yes,
looks at paragraph 2, the present writ petition has been filed, stating that despite interview, the petitioner's name was not recorded in the panel and marks were not awarded. Since the writ petition has pursued this claim in respect of the opposite since the year 2015. So my lordship kindly sees the year of the writ petition 2024. They have filed a fresh writ petition in 2024. They were not pursuing any further other writ petition, earlier writ petition of 2015. Even page, my lord, even page, if your lordship kindly sees, page 73 is another instance, and page 80 is another instance. These are all fresh writ petitions of 2024. These are not by way of supplementary affidavit or amendment application.
Okay.
I'm grateful to you.
Now, what I was submitting, if you allow me, therefore, these 4 councils are guilty of illegalities repeatedly. Why I'm telling your lordships? Your lordships kindly take up the writ petition once, just for a moment, because I will not be on much on this. Your lordships will be finding one annexure that's at page, my lord, 39, 21st June 2012. My lord, your losses will find the prelude paragraphs, all are, my lord, regarding deserving candidates have been, my lord, deprived. Your losses take up the 4th paragraph. Whereas the chairman DPSC North 24 Parganas, South 24 Parganas, Howrah, Malda have detected serious irregularities in the recruitment examination. Then your lordships, last paragraph. Now, therefore, in exercise of the powers given under section 107 of the Act, the governor is pleased to order that the aforesaid recruitment examination conducted by the councils, North 24 Parganas, South, Malda, Howrah, be cancelled, and directs the respective chairman of the concerned district primary council to conduct the recruitment examination de novo, provided that only the eligible candidates who had applied for recruitment against the advertisement issued by the concerned district primary school councils and had appeared in the written examination are allowed to appear in the de novo examination, and no separate fees are collected from them for appearing in such examinations. So, my lord, 2000 selection process was cancelled by the honorable governor by this order. Then, my lord, de novo process started.
Yes.
Now your losses will find de novo process. My learned friend has said much about Apurva Karmakar. I will deal with that, your losses. Kindly have a look at the very next annexure, page 41. Call letter for written test examination of recruitment of primary teachers under District Primary School Council, Malda. So they were asked for, again, in 2014 for appearing. Why I'm saying it, lordships? Because these are the things ultimately reflected in the order of the Justice Mantha. Whosoever appeared and interviewed. So I was interviewed, all the petitioners were interviewed. 7 has already got appointment, out 10 have not. Matlab, I am really pressing 9 out of them. So matlab, they are all interviewed. Now matlab, this 2014 interview did not culminate into a conclusion unless and until this honorable court directed them, you just publish the panel, and that panel was published 2021 on 8th January, as my learned friend submitted. Now, before that, this writ petition was filed. Well, what was the prayer? Publication of the panel. Second, appointment of the panel candidates. Third, including the petitioners. So far, prayer of my appointment still survives in the writ petition. Kindly have a look at the prayer portion, your lordships. Why I am saying this, your lordship, that I will develop because of the factual background. Your lordships will find prayer A, page 35, in Malat concluding part, including the petitioners. The out of the petitioners, according to them, 4 got appointment from the main panel. 3 got three. My lord, according to us, 4 got from the main panel, and 3, my lord, on the basis of the subsequent writ petition of 2024.
Yes.
So, my lord, I do not know whether they disclose this writ petition also pending before this court or not. But they got also appointment on the basis of subsequent writ petition. I'm not also aware of the date of that writ petition. I do not know. Why I'm saying this, I will tell you, lordships. Now, unfortunately or fortunately, this writ petition could not be included in the list before the Honorable Justice Mantha. Had it been done, Malad, they already these 9 persons could have got appointment. Why I'm saying it to lordships? Kindly have a look at this. Infractures, my learned friend is saying. Malad, page 103 of the Malad supplementary affidavit. Then I will take your lordships to the main order of the Justice Mantha. Malad, kindly have a look at this. This writ petition of 2015, order dated 1st May 2024. Kindly have a look. 2025 panel was not published, so there could not have been any dispute regarding the preparation of the panel. The writ petition participated in the de novo selection process of 2012 conducted by the Malda. The writ petition has been filed on 7th May 2015, even before us. In those circumstances, they are entitled to the benefit of the order dated 26th April 2024, as corrected on 30th April. Writ petitions disposed of. No appeal, appointment has been given. How can my learned friends say, my lord? I'm putting a question to myself. That my petition becomes infructuous. So condition before this court or considerations before the court, 2 things, as your lordships pointed out in paragraph 13 of the order at page 19. Your lordships kindly come, I just take your lordships to that. Running page 23, it starts at page 19, paragraph 13. In the above circumstances, the following order for the reasons stated therein in respect of DPSC Howrah, this court by consent of all the parties inclined to direct that all the candidates were called for interview. I was called for interview. I am showing the documents, your losses. There cannot be any denial. And have filed a writ petition until 25th April 2024. All of the only consideration that this must be related to the selection process. What was the subject matter? What was the crux of the writ petition? What was the content of the writ petition? Immaterial. Because illegalities was galore. But if I am not wrong, my lord, I appeared for the one of the council Howrah. When Justice Mantha passed an order, Justice Mantha said to me, Mr. Sanal, I'm aware that I am doing certain illegalities. But I have to do it, otherwise entire panel will go. Which one will you accept? On appearing on behalf of the House, I accepted the second one, give all the appointments. Whosoever come up by this date. That's the original Howrah's order, your lordships. And a copy, no? Your lordships, keep it on record. I'm not placing it. If your lordship requires that, kindly see this order. This was the genesis of the everything. Howrah started it, then North, then South, then Malda. These four districts have been doing since from 2009. Galore, my lord. Even the persons who have secured lesser marks have been appointed. My lord, there are other points also. So I had to accept that one because those persons have been working, your lordship, suppose appointment in 2021. These are 23. So if those persons' appointment goes, that will be havoc even for the government. So council instructed me to submit that whosoever have come up by this time, I will give the appointment, subject to creation of post or existing vacancies. So these were the consideration before the court. The two things, 2 yardstick. First, whether they have been interviewed, called for interview or not. And second, whether the writ petition filed before the court before 25th April 2024. I have shown to your lordships one order to 100 page. I will show other 4 orders. How this council have proceeded. None of the cases they have appealed appointed have been given. Threat of contempt, my saying, your lordship, my land in one case. What is the law? I'm asking myself. If there is a contempt, you can comply, but you can still appeal and get the order, challenge that order that this is a wrong order. This is the law. Under the threat of contempt, you are saying appointment. All right, you give it subject to the result, having reserved your right to appeal and get it done. You have not done it. So you are picking or choosing someone. Just because someone's writ petition could not be heard within time.
Yes.
Then your lordships, I take your lordships to the other order. One by one, I will show your lordships. Because this is the point, your lordship. Kindly have your lordships come to page 67.
I'm sorry to interject, my lord, senior friend, my lord. No, my lord, we are on the point of maintenance.
That's I'm showing the maintainable.
My learned friend is taking your lordships to the merit.
No, not merit. This is I'm showing maintainable.
I'll come to the point of merit.
This is I'm showing. My learned friend says infructuous because I prayed for panel preparation and that publication and panel and appointment. My including my appointment that still survives. That's I pointed out. Now what I'm saying that in respect of other writ petitions which was filed earlier, they have been also allowed. They have been given. So how can my learned friend take the point of maintainability? It's a selective maintainability point. You are taking by selection that I will take against him, I will not take against them. You can't do that being a state authority. I will show one after another. I'll deal with all the points. These are on maintainability, my lord. Let's kindly come to page 67. This is the 2015 writ petition. Varieties of situations I will show to your lordships. Order dated 5th May 2015. Kindly have a look at this. This is against Malda. Heard both sides. It appears that the candidature of the petitioner was cancelled by the respondent authorities at the time of interview, although he was called for written examination and selected for interview. Accordingly, the council is directed to hold a special interview for the petitioner and to produce the result of the petitioner in a sealed cover by 4 weeks from date. This order is without prejudice to the rights and contention of the parties and subject to the result of the writ petition. Mr. Bari is directed to communicate this order to the council and the council directed on that basis. Matter to appear after 5 weeks. Now kindly see your lordship the next page. On 13th May, this appeared again. Petition. Just a minute. Now this was the done. Now your lordship, then he moved after cut-off date, 25th April. This writ petition was filed by the same person. This is another example I will show. 3-4 examples I will show how they have proceeded. Now, what is the point? See your lordships, kindly have a look at this case. না সবগুলোই দেখিয়ে দিচ্ছি দর্শকদের কি কি সিচুয়েশন Malad, the petitioner participated in the recruitment process of the 2009 conducted by the Malda district. The writ petitioner approached this court by way of WP such and such. The said writ petition was disposed of, directing the council to take the petitioner's interview. The present writ petition has been filed stating that despite the interview, the petitioner's name was not recorded in the panel, marks were not awarded. Since the writ petitioner has pursued his claims in respect of the aforesaid recruitment process since the year 2005, notwithstanding the fact that the writ petition has been filed on 3rd May 25, that means after cut-off date, he is entitled to the benefit of the order. Why I am showing it to your lordships? My learned friend says that I ought to have come up with a fresh writ petition. That's now what is the difference between the two? Finding of the court's conclusion is that he is pursuing the claim. For 15 to move, get interview done, and then even after cut-off date, though he comes up, since he is pursuing, I will give him the relief. So, my lord, this behind the mind of the court that the illegality is so galore. So, what I am doing, your lordships, I am still pursuing before your lordships. Your lordship has to see the content of the judgment, not by bare words. What's the purpose the court allowed him? That he is chasing the court. He is chasing his remedy. So, I am still chasing his remedy. Supplementary evidence is permissible. I am bringing the subsequent events only in the pending writ petition. I have not shown you something else. In the same selection process, what I have done, I could not get it listed, your lordships. Missed it somehow or other. Then your lordships kindly see is 85. I am showing your lordships various examples in respect of this council only. Kindly look at this, your lordships. This is of 2017. I don't know, your lordships, cost title is legible or not. WP number 13553W of 2017. Page 85. 3rd May 2018. This order. So, my lord, this matter was also before publication of panel. Now, this was disposed of, my lord, 2018. No, I am coming to that. Kindly have a look at that. Second paragraph, Mr. Ghosh submits that the petitioner's name was sponsored in the year 2006 by the Employment Exchange when he was below 40 years, which is the age limit for the said post. The Ghosh submits that the petitioner is very much entitled to the appointment. The submission of Mr. Ghosh is vehemently opposed by Mr. Bari. Bari submits that he has to take instruction whether his name was sponsored or not on 2006. Now, this was kept pending then. Your lordships will find up to page 100, this writ petition was kept pending. Then your lordships will take the page 100. This is the final order of 2017 writ petition in 7th May 2024. Look, the petitioner has challenged the selection of the recruitment process of 2009. Why the court is saying? Because he said that I was not overaged. Allow me. Then your lordships kindly see, the petitioner is therefore within the cut-off date mentioned in the order in 26th April. My lord, I fail to understand how could my learned friend, after accepting all this order, say my writ petition become infructuous? I am still with the prayer of my appointment. Whatever has happened, all subsequent facts, the court has allowed, honorable court has allowed to deal with this. Okay. He shall be entitled to the benefit. Now, another your lordships will find, why I am saying all these, the court only wanted to be satisfied two criteria, whether you were interviewed and whether you have come up before this court before the cut-off date. And that too in relation to the selection process. Whatever the nature of the writ petition, court did not bother about it. Somebody has paid appointment, somebody says I have been illegally overaged declared, somebody simply says publish the panel. Even then they have been given benefit. I will show that, your lordships. Now see, your lordship, page 27. This is a writ petition of 2021. Initially the writ petition dismissed for default. Dismissed for default. Your losses will find in the very first can 4. Then can 3, explaining the absence of the petitioner, all that. Now your losses, kindly see. Page 28. The writ petition has challenged the recruitment process to the post appointed by DPSC 2. The writ petition has been filed in the year 2001. They are therefore within the cutoff date. Nothing, court didn't go into this. And all these orders they have accepted, my lord. Page 27 onwards. Now kindly have a look at your losses. I have not placed it also. Page 20, 30. Can was only for restoration. Page 30. This is of 2015 writ petition. Eta place going to just have 30. Again? No. Now kindly see your losses. Order dated 1st May 2024. The writ petition participated in the dynamo selection process conducted by Malda. The writ petition has been filed such and such. In those circumstances, they are entitled to benefit. All accepted, man. Even this was ex party, if I am not wrong. Even then, they have not appealed against.
Okay.
So this is the situation, your lordships. Now kindly have a look at this, your lordship. Page. The other things from the existing vacancies or future vacancies. Now your lordships, page 15, I tell your lordships.
Yes.
Now kindly your lordships is notified in terms of the order passed. Nihat Bishas, my learned friend, has placed a copy of the order. I am not taking your losses. Kindly see, so far Malda district is concerned, 1050 posts were created for this purpose. And then your losses will find 18. Okay. Now your losses will find this is how much posts have been filled up by joining or non-joining report. Your losses will find at the top status of category wise joining candidates given below. That's your losses 857. And then
which page you are referring to?
Page 18.
Yes.
Now status of category wise non-joining candidates is given below. Kind level look, total 431 vacancies. Out of them, they have appointed 312. They have, and I have annexed the panel also. Kindly record that out of this non-joining 431, they have appointed 312. I have annexed the panel also. So therefore, your losses, the 119 vacancies are still there. They don't want to go to for future vacancies either.
431 not joined.
Initially didn't join. Then they appointed 312 further. Because of these writ petitions, all of them, whosoever came, court directed them to be appointed. And then 119 vacancies, 119 still exist.
312, where I'll get that?
That panel I have annexed. Page 53, your losses. Your losses, this is a memo of page 18, 2nd November 2022.
312, yes.
And kindly see page 53, 27th February 2025, this year. Kindly have a look at this 312. I'm showing that this vacancy still exists. They can't take the point. Even in spite of that, even they say, so take it. Direction of the Justice Mantha loss against future vacancies also. Okay. So this is the other point I tell you, lordships, why the court has taken lenient views. Because of he gallowed discrepancies. It was not, my lord, possible even for the authorities to wade out. Wade out means who have got the illegal benefits and who have not got. So the court fixed up a cut-off date. By this time, whosoever filed a writ petition pertaining to that selection process, whatever may be the prayer, they have been allowed. Now, so far one complaint has been made, mother's name, father's name. I tell you, Lordship, that's not the intention of any candidate. These, my lord, third, my lord, to 2024, 3 persons have been appointed out of the present writ petitioner of the fresh writ petition. My lord, I request your lordships, call for the records. You will not find that they have disclosed that this present writ petition is pending. My lord, they are honest enough that they have, in the pending writ petition, they have come up before your lordships with a supplementary evidence. Look, this is the situation and this is the conduct of the council. One facts, my lord, can be viewed from two different angles. My learned friend is saying that I have filed a subsequent writ petition. That's more the so, my lord, cannot be a ground for dismissal of this. Cannot be a ground because the others have been moved and you have allowed them.
Okay. Who are the persons who filed the subsequent writ petitions?
My lord, I think the other supplementary affidavit I have given your lordships,
8, 9 and 15.
I think 3, 6 and 11.
No, 3, 6 and 11 has been
they were
given.
Oh, sorry.
This petition number 1, 8, 9 and 15.
What?
8, 9 and 15 filed separate writ petitions. Appointment given.
Given. During pendency. You could have taken a point. Look, your earlier writ petition is pending. Have you disclosed it? You didn't. Like, nobody could make any submissions before Mantha.
And who is
Justice
the
Mantha.
seventh person who has been given appointment?
Oh, it's 4 and 3 and other 3, 3, 6, 11 from the main panel.
4 and 3.
No, 4, no. 3, 6 and 11.
3, 6 have been impaneled and given appointment. 8, 9, 15 after they subsequently filed writ petition, they have been given appointment.
They have been given on the basis of
Have been
subsequent
given.
writ
So
petition.
11 are left.
10 left. 17 has also got, according Sujata Das. 17 has also got an appointment. She has also.
17 has also got.
পেয়েছে আরে পেয়েছে বলছি যখন পেয়েছে তোর তো আরো ভালো হয়ে গেছে যে চলে গেছে আর আসবে না
সেটা ঠিক নয়, সেটাকে বলবো।
17. My learned friend is saying 17 has not got an appointment. That's maybe, may not be.
He has some interest.
Serial number 5.
Serial number 5 in the panel. Page. Supplementary affidavit page. না দেখিয়ে দিচ্ছি ও দেখিয়ে দিচ্ছি বলছি দাদা মানে এটা supplementary the one I filed today page 12 page 12 serial number 5 Sujata Das. He got it, I mean, she got it under the PH category. Serial number 5. Sujata, whatever may be, the general. PH category general to hoti pare.
Names are not clear here.
That's Sujata Das, may read it. I don't know, my lord. Sujata Das.
Yes, yes. Serial
Sujata Das can be, my lord. I'm sorry, my lord.
Yes, yes.
I'm pressing
Please.
hard to your lordships.
Serial 5.
Serial 5. So he was in the panel also.
So he has been given appointment.
Given appointment.
Pressing for
9 only. 9 bole daw na kon na. Matlab these are the 9 writ petitioner numbers. Apurbo Karmakar. 1. Then your lordships, I just give your lordships. Debashish Bishwas, number 2. And then your lordships, Sushanto Sarkar 3. No, not. Just my lord, 1, 2, 4, 5. 1, 2, 4, 5. 10, 12, 13, 14. And 16.
Sorry.
No, not here.
So, Malad, the other petitioner, one petitioner is left out. Out of
Malad, he is not approaching. I tell you, lordships, Malad, there are two things. Malad,
his serial number.
that serial number. Just a minute. 7. We have disclosed it in the supplementary today file. 7. But two things, Mr. Tale Mahathir Siddiqui also knows. Well, suppose we move it Malad jointly for 10 or 20. Somebody get appointment. He will never come up to the lawyers. He will never come up.
That reflection should be there in the order sheet.
Well, that-
These are pressing their prayers, none and rest are not pressing.
That's your lordship. That's supplementary affidavit.
It has to be clarified.
That's supplementary affidavit, your lordships.
7 is
Paragraph. ও কত বলে দাও?
7.
এই তো, তলে ছিল। এইটা নাকি? এইটা। Paragraph 9 and paragraph 5.
Of the earlier one.
Abhiga?
Earlier supplementary.
No. Today, which one I filed? Malad, thin one. 5, 9, and 10. The difficulty, I tell you, loss is practical. Those are not coming because they have got appointment. So I cannot make, the other petitioners cannot make a submissions before the court that they are not wanting anything because they have got it admittedly. On record, this is Malad. My learned friend is also submitting that. 5, 9, and 10. Your losses will get it everything.
অভিজিৎ চৌধুরী আসছে না। তোমার কাছে পিটিশন নাম্বার 7 নেই, অভিজিৎ চৌধুরী আসছে না।
নাও আসছি না, ও তো আরো বেটার পেয়ে গেছে কোথাও।
That's all.
That's my submission. Therefore, that's the views, your lordships. And so far, Kormokar is saying another. I've made submissions that look at the other petitioner of the same batch. They have also subsequently moved it because they are searching for employment because of this. And the court has taken that view, and I tell you, lordships, lenient view. Much obliged to you. I'm just
want to take your lordship to the merits of the case, my lord. Senior friend has take your lordship to the merit of the case. Now, my lord, the orders which were relied upon, that the old writ petitions of 2017 and 15 and 19, those writ petitions has been disposed of by my lord Justice Mantha, saying that even if you have come after the cutoff date, but since you are pursuing your case, you should be given appointment. But your lordship, my lord, since my learned friend, thank you from what he has submitted. But he said, even Apurva Kormakar, my lord, these are people coming from villages. He could not disclose because they are desperate for the job. But similarly, why my lord was pleased to pass the orders. If your lordship now looks at the dates of all these orders, page number 31 is the from the first supplementary affidavit. Page number 31.
Yes.
Lord, the date is 7th of May 2024. Well, 26th of April 2024 was the cutoff date that is mentioned in paragraph 2.
Yes.
26th April. Well, within 10 or 15 days, he has come. Now, my lordship, this will be a never-ending process. My learned senior friend says he appears for Malda, Howrah DPSC. He has given that concession. But that doesn't mean, my lord, everyone will come and say, even though they were not impaneled, after 2 years, 3 years, because there is a life of a panel. The law says a panel is there for 2 years. Honorable Justice Mantha said that you give them appointment. we lost before the Honorable Supreme Court. We are started giving them appointment. The panel is for 1 year according to Rule 13 of the recruitment rules, which can be extended for further 1 year. The law is for 2 years. Now, within how many days, if your lordship kindly sees? 7th of May 2024, that is within 10 days. Then if your lordship kindly sees page 68. 13th of May 2024, that is another 17 days. 2024, not even 25. আর পেজটা বলেন, পেজ নাম্বারটা লিখেছিলাম তোকে তো 103.
And a panel is valid for which date?
Panel has expired, my lord.
Then
Panel has expired.
on the date this order was passed, panel has expired.
Panel has expired.
Then
First, my lord Justice Mantha was of the view, even though the panel has expired because they are pursuing those cases, and since 2024 he has fixed a cutoff date. So within this cutoff date, whoever has come, you give them appointment. But there were some writ petitioners who were pursuing these cases. But when they came to know about this order, immediately they approached my lord Justice Mantha. Within 10 or 15 days, certain orders were passed that even though that 26th April was there, because they were pursuing, you give them appointment. But some writ petitioners who filed writ petitions or who challenged these actions, that since these writ petitions have been given appointment on 26th April 2024, this is with regard to 4 districts. So with regard to 1 district, some writ petitioners came very late. The Honorable Single Judge, after Justice Mantha, was pleased to dismiss the writ petition on the ground that since you have come late, 26th April 2024 was the cutoff date, so you cannot be given that appointment. That order was challenged before the Honorable Division Bench. Your Lordship, kindly, I'll just, my lord, from the beginning, my lord, your Lordship, kindly see the appeal is directed against the order dated June 13, 2024, passed in WPA 1 for this 13 June order, my lord. By the impugn order, the learned single judge dismissed the writ petition of the appellants on the ground that the appellants cannot come within the scope and ambit of the earlier order dated April 25, 2024. Learned advocate appearing for the appellant submit that the aforesaid writ petition is similarly situated in circumstance as that of the writ petitioners who were afforded the benefit of appointment by the order dated April 25, 2024, passed therein. He submits that the appellants were called to the interview. Therefore, according to him, it comes within the scope and ambit of paragraph 13 thereof. Thereafter, the state submitted. My Lord Justice Mantha's paragraph 13 has been quoted in bold in page 3. My Lord, under paragraph 13 of the order dated April 25, 2024, twin conditions are required to be satisfied by participant selection process to the post to be entitled to a permanent. Such participants were called for the interview in recruitment process and filed writ petition until April 24, 2024. Learned advocate appearing for the appellant submit the learned single judge fixed April 25, 2024, and unilaterally as recorded in the order dated April 25. According to him, since the appellants are similarly situated in circumstance as that of the other candidates who participated in the selection process and were called for the interview, the appellant should also be granted the appointment. With respect, we are unable to accept the contentions of the appellants. Appellants never assailed the order dated April 25, 2024. The order dated April 25, 2024 prescribes twin conditions which must be fulfilled simultaneously. Being party to the writ petition filed before April 24, 2024, we are informed that the order dated so and so is under challenge by the state. Thus, such appeal is pending. Learned single judge found the appellants before us not only to fence seaters but also not qualifying the conditions prescribed in the order dated April 2025.
no, when was this writ petition filed? This was filed after the order passed.
Order passed.
Then these petitioners have filed their writ petitions in 19. How this will apply in their case?
But because they were the fence seaters, the ratio which has been laid down.
Ashun.
They are the fence seaters.
But 19 writ petition, we are in 19 writ petition. This
We
was
are in
filed
2019 writ petition. We were in 2019.
7th November 2019. This
November 2019, but thereafter 2021, my Lord Justice Chakraborty directed all the councils to publish the panel.
I have heard you.
We have done so.
Ashun.
But may I take your lordship's name?
Yes, thank you.
My Lord, your lordship is disposing of the writ petition, my Lord, itself.
Why?
Your lordship, can you dispose of? Because, my Lord, I was thinking that if your lordship's hold is maintainable, my Lord, I would have filed it, completed the pleadings in this matter. But since your lordship has heard it, my Lord, I think, my Lord, your lordship
we consider both the merits as well as.
I'm grateful.
নামটা কি? What is this CAN application for?
What?
CAN?
May I just, may I see the application because the change brief, my lord.
না আমার লাগবে না
The CAN is for early disposal of the writ petition.
I'm for the state respondent.
আমরা পাইনি স্যার
এই, আজকে
But I'm taking your lordship's
Yes,
but
yes.
I'm grateful to your lordship.
supplementary bill state ke down.
Supplementary affidavit filed on behalf of the petitioner is taken on record. At the very outset, by the present writ petition, the petitioners have sought for publication of the panel with regard to a recruitment process initiated in the year 2009 and for issuance of appointment letters in favor of the impaneled candidates, including the petitioners forthwith. Para. The writ petition is moved on behalf of petitioners numbers 1, 2, 4, 5, 10, 12, 13, 14 and 16. Para. At the outset, Mr. Siddiqui, learned senior advocate appearing for DPSC Malda, submits that the writ petition is not at all maintainable since it has become infructuous, inasmuch as the petitioners herein have prayed for publication of the panel, which has already been done on 8 January 2021, pursuant to order passed in WPA number 15128 of 2017, along with other writ petitions, Nihar Vishwas and others versus State of West Bengal. 125128 for Redevan and others. Huh? Nihar Vishwas 125280.
The panel was published in the month of February. The order was passed on 8th February.
Yes.
8 January is the order.
Already 8
Yes.
January is the order,
Pursuant to the 8 January, what is the date of panel?
10th of February 2021.
10th of February 2021, pursuant to order bolun, passed by in on 8 January 2021. The petitioners, by way of supplementary affidavit, has tried to mold their prayers and sought for their appointment, which is a change in cause of action and should be placed into service by way of a separate writ petition. Stop. He further indicates that three of the petitioners, namely petition number 3, 6 and 11, have been impaneled and given appointment. and other three petitioners, namely petition number 8, 9 and 15, filed separate writ petition. আচ্ছা ওইখানে না full stop দিয়ে দিন তো ওইটা and কেটে full stop দিয়ে দিন. Petition numbers 8, 9 and 15 filed separate writ petitions and pursuant to order passed in those writ petitions, appointment has been given, comma, such fact has not been disclosed in the present writ petition. It is a settled proposition of law that equity can be claimed by the persons who comes before the court with clean hands. There is suppression of material facts. Stop. He also indicates that petitioner number 1, Apurva Karmakar, has mentioned the name of his mother in the cause title, and in the subsequent writ petition filed by him, being WPA 13419 of 2024, he has mentioned his father's name in the cause title. What is the prayer in that writ petition?
Prayer কিছু বলুন। In the writ petition, Oruna mother's name was disclosed.
No, what is the fate of this writ petition?
My lord, it is still pending. Still pending.
This you have mentioned in supplementary.
No, my lord, nothing.
But this was not within my knowledge.
The supplementary.
This is
has-
pending before which court?
My lord, it is before this High Court, and my lord, there was
Before
one.
which court? This is pending.
If your lordship's court, perhaps because this is primary education matter.
But then similar prayer has been pursued in their subsequent writ petition.
Okay, but
And one more thing, my lord, the supplementary has been affirmed by the Apurva Karmakar in this writ petition.
petition.
Have you filed your Vokalatnama?
Yes. I filed my Kolatnama.
Why this has not been stated to you?
No.
See, prayer B is a similar prayer for issuance of
Yes, yes.
appointment date.
That's why it has been pointed out.
Pending লিখে করবো।
Here the prayer is, my lord, to give appointment against the non-joining vacancies.
That is what is.
Yes.
He is also pursuing the same remedy here by supplementary.
Then hold on, করুন তো। Call Mr. Sannal and Mr. Siddiq.
Non-joining vacancy appointment.
It's
ওই আরেকটা নতুন রিটের কপি আছে? দেখি। ওই যে ওই অপূর্ব বলে।
Sannal, number 1 has filed the writ petition praying for the similar relief as has been advanced by you. Now that writ petition is pending.
I tell you, Lordships, my lord, the twofold of submissions I could make on this. My lord, your Lordships should take, according to me, certainly, should a lenient view. Why I'm telling you, this is not a fraudulent act as such. Only he should not, had not disclosed. For that, your Lordships can put him any condition. But kindly visualize, I have taken your Lordships so long
So
the
that is
orders.
correct. For the sake of records, if suppose this writ petition is disposed of and this is kept pending,
My lord,
the
he
similar
is present with your Lordships, record his undertaking that he will not proceed with the second one. He cannot. But my lord, the factual things are so galore, your Lordships. What happened, I tell you, because other petitioners have moved and got. So he thought probably that if I get it, my earlier writ petition is not being heard. I will get
I
it.
get that writ petition before this court tomorrow and place this item for orders along with this writ petition and record your submission accordingly, because he has made a similar prayer in the subsequent writ petition. Number 1, Apurva Karmokar, which has not been disclosed in the
Supplementary
affidavit. But while disposing this writ petition, that cannot be kept pending. So what I do is I place this for orders tomorrow and get this writ petition along with that.
But I do
Because
not
that
know
has to be
that-
dismissed or withdrawn, whatever. He says that he will withdraw that writ petition.
So far he is concerned.
So far he is concerned because there are several
Several persons.
several
That your Lordships can record that today also. He is present, personally present.
If he wants to get himself withdrawn from that, your Lordship may kindly record that.
And do
Yeah,
that.
that will be placed in
And
that.
so for the others, your Lordships, there is no difficulty.
But that writ petition has to be listed before this court.
No, your Lordships,
Subsequent one.
your Lordships record that this fact and record his undertaking that he will not proceed. So far he is concerned with that writ petition. That will do.
As petitioner number 29, he will not proceed in that particular.
That your Lordships do. Because the others are there, they may proceed, they may not proceed.
Ashok.
But may I, within 5 minutes, I will
Because
come back.
there are different advocate and records, my lord, that will be problem.
A problem, but really problem.
But I'm taking
Yes, yes.
29 আছে সম্ভবত।
Huh. First step. না লিস্টে রান করছে না, ওটা আন্ডারটেকিং দিয়ে ওটাকে বলে দেবো যে withdrawn. Mr. On the contrary, Mr. Subir Sannal, learned advocate for the petitioners, submits that the petitioners in their prayer, apart from praying for publication of the panel, has also sought for issuance of appointment letters in their favor. The order dated 26th April 2024, page number, sir.
Page number 19 of first supplementary video.
Does not specify the nature of writ petition. The conditions are that the petitioners had to be called for interview in the recruitment process of the year 2009 and have filed writ petitions until 25th April 2024. The present writ petition has been filed on 7th November 2024. Therefore, the instant writ petition is very much maintainable. In the recruitment process undertaken in the year 2009, there was irregularities galore, which prompted this Honorable Court to pass orders with the aforesaid twin conditions. Subsequent orders have been passed by this court, wherein benefit of order dated 26 April 2024 has been extended to the petitioners who fulfill the twin conditions. He informs his court that petition number 3, 6 and 11, 8, 9 and 15 and 17, no?
Yes.
17 has already got appointment. Petitioner number 7 is not tracing his prayer before this court. Therefore, the petitioners number 1, 2, 4, 5 একবার বললাম না, seeks for similar relief as has been extended in favor of the candidates who were called for interview and who filed writ petitions within 24th April 2024. Referring to annexure 431, it's in first one,
Yes, my lord.
page.
Page 18.
Referring to the non-joining.
Yes, my lord, page 18.
18. Referring to page 18 of the supplementary affidavit dated 5th August 2025, he submits that there are 431 non-joining candidates, out of which 312 have joined. Stop. Therefore, there are still vacancies in which the present petitioners can be accommodated and given appointments. He seeks for appropriate direction. Mr. Siddiq Lanet, Senior Advocate, Para, in reply submits that this court has turned down the prayer of the petitioners who approached this court after 25th of April 2024. Therefore, the petitioners should not be extended the benefit of the order dated 26th April 2024. Upon hearing the learned advocates for the respective parties, following issues have fallen for consideration. Firstly, whether the writ petition is maintainable in the present form. Secondly, whether the petitioner numbers 1, 2, 4, 5, 10, 12, 13, 14 and 16 are entitled to the benefit of order dated 26th April 2024 passed in WPA 25718 of 2022 within bracket Muhammad Asiruddin and others versus State of West Bengal and others. Para. With regard to the first issue of maintainability of the writ petition, it has been strenuously pressed into service on behalf of DPSC Malda that the prayer of the petitioner for publication of panel has been satisfied since panel has been published pursuant to order of this court passed in Nihar Vissa Supra on 8th January 2021. In this regard, this court finds that apart from praying for publication of the approved panel, the petitioner has also prayed for issuance of letters of appointment in favor of the impaneled candidates, including the petitioners. Therefore, such argument advanced on behalf of DPSC Malda does not stand to reason. The other aspect which has been argued by the learned senior advocate for DPSC Malda is that the petitioners ought to have filed a separate writ petition since the cause of action is different. It is not in dispute that appointment has been sought for by way of the present writ petition filed on 7th November 2024. The supplementary affidavits filed discloses certain facts and is a continuing cause of action of the original writ petition. Therefore, the prayer of the petitioners for issuance of appointment letters can be considered in the present writ petition. More so, it has been argued that there is suppression of material facts. Suppression of material facts arises in the context when it is relevant for adjudication of the list. Some of the petitioners have already been granted appointment. Therefore, such does not affect the list so far as the remaining petitioners are concerned. Therefore, in light of the above discussion, it is found that the writ petition is very much maintainable in its present form. Next para. By order dated 26 April 2024, passed in WPA, origin that order is at page number
19.
90. Two 25712 of 2022, Muhammad Asiruddin and others versus State of West Bengal. The coordinate bench of this court, after considering the irregularities and improprieties in the recruitment process of 2009, directed as follows, para 13. এই দেখুন, এটা সাপ্লিমেন্টারি অ্যাফিডেভিটে পেজ 23 টা সেকেন্ড পেজেও যাবে, লাস্ট লাইন। Para. The aforesaid order was order of recall of that. Where is that order of
Page 44.
was recalled on 25th September 2024. This was challenged before the division bench, or
Yes, page 36 is the order of division bench.
Initial
After
challenge,
that, my lord, review was preferred.
my lord, initially challenged before the division bench.
this order was challenged in appeal before the Honorable Division Bench in MAT 1057 of 2024. District Primary School Council Manda and others versus Muhammad Asiruddin and others, bracket close, along with other appeals. And the appeal was dismissed. Against this order passed in the appeal, where is the order of the Honorable Supreme Court?
After dismissal of appeal, they preferred the review application. Then the review was allowed. We have the petitioners therein challenge the review.
That is over. Now the division bench has dismissed the appeal.
Yes.
After that, civil appeal was SLP was filed.
After that, they preferred a review application.
My lord, initially, my lord, I am clarifying. My lord, against the 26th April 2024 order, the parent order, the inter-court appeal has been filed. In that appeal, my lord, the Honorable Division Bench, though my lord dismissed the appeal, but given a liberty to approach the single bench.
Achha.
Thereafter, my lord, review filed. And in the review, it was, the main order was
Okay.
recalled.
Against that order, no.
Then no appeal, directly to the Supreme Court.
Okay. কি বললাম? না, ওই this order কেটে দিন। The order dated 26th April 2024 was challenged in MAT 1057 of 2024. The appeal was dismissed. However, liberty was granted to the appellant.
Page 43.
43.
Yeah. The very first paragraph.
Appellant to pursue the remedy in accordance with law. Subsequent thereto, review petition was filed before the single judge and the order dated 26th April 2024 was recalled. Against the said order, special leave petition was filed before the Honorable Supreme Court 27722 of 2024 within bracket civil appeal number 853 of 2025, whereby the order of recall of the single judge was set aside and the order dated 26 April 2024 was restored. Para. Several candidates who qualified the twin condition approached the court and they were extended the benefit of the order dated 26th April 2024. The petitioners is similarly circumstanced as of the candidates who have already been extended benefits. Accordingly, the petitioner numbers numbers are 1, 2, 4,
1, 2, 4, 5, 10, 12,
13, 14, and 16. 1, 2, 4, 5, 10, 12, 13, 14, and 16 are entitled to the benefit of order dated 26 April 2024. The petitioner shall be entitled to appointment on the same terms and conditions as mentioned in the aforesaid orders. With the aforesaid, it is indicated by Mr. Siddiqui Lanet, Senior Advocate, that petition number 1 has filed another writ petition along with 28 others, being WPA 13419 of 2024, 13419 of 2024, seeking similar relief. To this, Mr. Sannal submits that the petition number 1 undertakes not to pursue his prayer in WPA 13419 of 2024. In view of the above, the writ petition is accordingly disposed of.
And we have paid the deficit court fees.
ওপরে দিয়ে দিন তো ওপরে supplementary affidavit এর নিচেও দিয়ে দেবেন deficit court fees filed by the petitioner. E-challan, right? E-challan showing deposit of deficit court fees filed by the petitioner is taken on record. Thank you.
I'm deeply obliged. Obliged.
ওই ক্যানটা ডিসপোজ করে দেবেন along with can one of
আপনার বিলটা আমার কাছে আছে, আমার
এই সুরিত বাবু, it is not in dispute that these petitioners have called for the interview and the writ petition has been filed on 7th November 2024. Twenty 7 বলে দেবো আমি, এটা 9টা রাখবেন, 7 November 2019. So, therefore, these petitioners fulfill the twin conditions of order dated 26 April 2024. Yes.
Number 603.
মানে I am for the district primary school count.
Secondary board
District south. প্রথমটা আপনার south. তারপরেরটা north.
I tell you, Losses, your losses, kindly do not open the brief first. Just I give you a nutshell so that your losses can have the glimpses of the matter. The petitioners are all qualified to be recruited for both secondary, higher secondary as well as primary teachers. Now, they were, my lord, selected in 2016 selection process. For the probably your losses, for the first time we are mentioning it, but this is now widespread. That entire 2016 selection process has been cancelled by the division bench first, and then your lawsuit, Supreme Court affirmed that. Now they were selected. Well, there are two categories of candidates found by the Supreme Court. That's subsequent litigation still continuing: tainted and untainted. Well, tainted, they cannot be allowed to even participate in the new recruitment process. But so far, untainted, Supreme Court has given them the protection that their age should be considered and they can participate in the next selection process. Further benefit has been given by the Supreme Court to them that they should be allowed to continue the service till the selection is completed. If they found selected again, they will continue. If they don't, they will not continue. Now your losses will find when this judgment was passed, when they were serving as such, well, all the petitioners are untainted. Untainted in relation to selection process 2016 of secondary and higher secondary. And they have been serving till date. That was up to 31st December. Now, 2 days or 3 days before, that has been extended up to August. Because selection process is not yet
Join.
what happened, my lord? But all appointments are terminated, both tainted and untainted, because the Supreme Court, according to the egregious completion of selection process, they cannot weigh out who is good. As a result, Supreme Court admitted that somebody, good persons are also deprived of their appointment, of their service after a long time. That's why they have been protected like this. Now, what happened, my lord? In the meantime, these present petitioners who are untainted in the secondary housing selection process also got selected in 2022 selection process of primary school teachers.
2009.
Oh, 2009.
2009, sir.
I'm sorry. 2009 selection process of South 24 Pop, which your losses was dealing in the first matter. Now, those appointments have been given in 21-22 like this. So, Malad, a person, if gets Malad, a better opportunity, obviously he will stick to that. It's a competition market, Malad. So they didn't go for primary, it's lesser salary. Maybe Malad, even no job is to be performed. I'm sorry to say that in the village area primary school. But the secondary schools, onerous job, but the salary is lucrative. So for the teaching, so they stick to 2016 service. But ultimately they suffered. Now they have come up that allow us to join in the primary. I will not say before your lordships that this is on the basis of the judgment entirely, but I will take, my lord, reference to the judgment of the Supreme Court, because the Supreme Court ultimately held that those who are untainted, if they had joined the school service, leaving their past service, either from government organizations, semi-government organizations, government should take them to allow to repatriate them to their earlier situation. So, provided that they have served over, serving was there. Lord, I cannot say I am serving because I didn't join the primary. No, Lord, I am praying that because of this situation, because entire act of the state is faulty. For that, a candidate or a citizen who is otherwise bona fide and got selected through a selection process, they should not be deprived. My Lord, in one matter, I have succeeded before Justice Shogato Bhattacharya. I will place that order, Your Lordship. But before that, I take Your Lordship to the Supreme Court, that particular part of the order. It starts from 185. But I will not take Your Lordships to the entire thing, only 223 page. Paragraph 45, 46, to I think 49 also. The last question, as well as got that one, page 223 running page.
Yes.
The last question relates to the relief and whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates where appointed must be terminated, and they should be required to refund any salaries or payments received. Since their appointments are the result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. Well, this is in regard to tainted. Now, 46. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void due to the egregious violations and illegalities, which violated Articles 14 and 16 of the Constitution. As such, the appointment of these candidates, that means untainted, are also cancelled. However, candidates who are already employed need not be asked to refund to restitute any payments made. However, their services will be terminated. Furthermore, no candidate can be appointed once the entire examination process and results have been declared for. Now, it is clear to your lordships the distinction, tainted and untainted one. Now, your lordships kindly consider paragraph 47. Some of the appointed candidates who do not fall within the category of tainted candidates may may have previously worked in different departments of the state government or with autonomous bodies, etc. In such cases, although their appointments are cancelled, these candidates will have the right to apply to their previous departments or autonomous bodies to continue in service with those entities. These applications must be proceeded by the respective government departments or bodies within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of their previous appointment and their rejoining will not be considered a break in service. Their seniority and other entitlements will be preserved and they will be eligible for increments. However, for the period they were employed under the disputed appointment, no wages will be paid by the state government or autonomous bodies. Further, if required necessary, supernumerary post may be created for the persons appointed in the interim. But I am not saying that I am wholly taking recourse to this because I was not in service, because I didn't join. But I tell you, losses, I am drawing impetus from this. And I succeeded one matter. Before that, I take your losses that we are untainted. I believe my learned friend will not dispute it. And we have been serving or we're being paid till the completion of the recruitment. But I'm not sure, mother, whether in this recruitment process again I will succeed or not, like the earlier one. But I have suffered this because of the action of the authorities. And as you also place that I need not place the entire judgment to losses. So these are the two factors, Malad. I'm untainted. I'm still serving, but this will come to an end as soon as selection process ends. So, Malad, I have lost the job. Malad, kindly will look at these judgments. Copy yourself. এটাই দিয়ে দেবো I will give my copies to it আমার সঙ্গে but I will place not a very longest judgment I will place it at এই ফটো তুলে নে না এখন আর লেখে কে
No, 1351.
Now kindly see affidavit of service that's not the point. Petitioners participated in the first state level selection test of 2016 for classes 11 and 12 as well as selection process of 2009 for being appointed as primary teacher in the district of Malda. It is submitted by the learned advocate representing the petitioner that in both the selection process, the petitioners got selected. But the petitioner opted to be appointed as assistant teacher of a higher secondary school to impart lessons to the students of 11 and 12. And since such appointment in terms of the service benefits and other emoluments is better option than to work as a primary teacher. The appointment letter was issued by memo dated 17 September 2018 in favor of the petitioner by the President West Bengal Board of Secondary Education, based on which the petitioner joined the post of assistant teacher in higher secondary section of a government-aided school in connection with his participation in first SLST 2016, classes 11-12. Subsequently, the petitioner was favored with the appointment letter dated 28 September 2021. I will take your losses to my appointment letter also. In connection with his selection in 2009 recruitment process issued by the chairman district Malda, here Malda South 24 Parganas, whereby he was invited to join as primary teacher, but the petitioner chose to work as assistant teacher in higher secondary section of a government-aided school instead of working as a primary teacher. The petitioner lost the job assistant teacher in higher secondary school in terms of the judgment of the Honorable Supreme Court dated 3rd April 2015. As I placed, Malad, only the operative portion of that. The prayer is made on behalf of the petitioner to permit him to join the post of primary teacher based on his selection in connection with his participation in 2009 selection process conducted by the Council of Malda. Mr. Prasad, representing the council, has opposed the prayer of the petitioner on the ground that the petitioner approached this court with this writ petition on 19 June 2025, which is much after the cut-off date, that is 25th April 2024, fixed by a coordinate bench. Your losses Monday morning, that judgment. This has no real relation to that, the cut-off date. Cut-off date only in respect of those. Factual scenarios completely different. But even then, your losses kindly see that. First one being such and such, wide order dated 26th April 2014 as placed before lawsuits also in the morning. It is also submitted that the order passed by the coordinate bench dated 26th April was not interfered with by the Honorable Division Bench while disposing of two intra-court appeals being such and such. Attention of this court has also been drawn to paragraph 21 of the writ petition, wherefrom it appears that in spite of issuance of appointment letter in favor of the petitioner for joining the post of primary teacher, he decided not to join the same post. It is also submitted on behalf of the DPSC Malda that at belated stage, offering the post of primary teacher in connection with the petitioner's participation in 2009 selection process may not be permissible. State respondents are represented by the learned advocate who adopts the submissions on behalf of the Malda DPSC. Having considered the submissions made of the behalf, issue needs to be decided whether cut-off date fixed by the coordinate bench by order dated 26th April 2024, that is 25th April 2024, impedes the authority in appointing the petitioner as primary teacher or not. On careful reading of the order dated 26th April 2024, it appears that on a peculiar fact situation, the coordinate bench found it fit to fix the cut-off date, stipulating two conditions. First, candidate must have been called for the interview process in connection with 2009 selection process for being appointed as primary teacher. And second, approach should have been made this court by filing the writ petition on or before 25th April 2020. It was decided if these two conditions are fulfilled, in that event, particular candidate needs to be appointed by the Council of Malda. In the present case, fact situation is totally different, where the petitioner not only participated in this interview process, but also he was selected and appointment letter was issued. In his favor on 28th September 2021, in connection with his participation of 2009 selection process. When the appointment letter was issued, petitioner was working as an assistant teacher in a higher secondary school, as a result whereof he chose not to join the post of primary teacher based on appointment letter dated 28 September 2021, as in terms of service benefits and other emoluments functioning as assistant teacher in higher secondary section of a government is better option than to work as a primary teacher. However, the petitioner lost his job in terms of the judgment dated 3rd April 2025, which prompted the petitioner to approach this court seeking direction which would permit him to join as a primary teacher since he was selected in 2009 selection process conducted by DPSC Malda, and an appointment letter in his favor was issued on 28 September 2021. Therefore, fixation of the cut-off date by the coordinate bench by order dated 26th April 2024 does not apply in the present case, considering the aforesaid special circumstances. Case at my hand is better than the writ petitions which are being considered by the coordinate bench and disposed of by order dated 26th April 2024, wherein it was found that the candidates, by merely participating in the interview process, needs to be appointed provided those candidates approach this court on or before 25th April 2020. Malad, I could not place it more hard than this. It's such a lucid language, Malad, that my Lord has placed it. It is submitted on behalf of the petitioner that he is an untainted candidate, as a result whereof he is still working as assistant teacher in higher secondary section of a government aided school. But that is only up to 31st December 2025. Malad, this has been extended up to August. After that, Malad, if I'm not selected, I will lose that job. Fact remains, petitioner lost his job, and the case of the petitioner is required to be considered sympathetically. It is also admitted position the vacancies are available for the post of primary teacher in the district of Malda in connection with the selection process of 2009. My instructions, vacancies are galore. But every day vacancy arises in the council. Every day. One teacher either resigns, retires, every day. Therefore, in the aforesaid special facts and circumstances, concern the authority of DPSC Malda is directed to appoint the petitioner as a primary teacher by issuing fresh appointment letter within a period of 4 weeks from the date of communication of this order, provided the petitioner is untainted candidate. The petitioner is going to appear before the chairman with his credentials within a period of fortnight from the date of communication in the order to his untainted candidate. If any formal approval is necessary, the Commissioner of School Education is directed to grant such approval within a period of 7 years. The logic behind that, in both the selection process, the petitioner succeeded. Lord, it is very common affair, my lord. If I am selected in true process, which one is better? Obviously, I will accept it. And they accepted it. Now, ultimately, it's found that the entire selection process is, my lord, based on fraudulent acts. But I was not a party to that, admittedly. And Supreme Court has described as untainted. But since the entire process is so, my lord, involved with the fraudulent activities, Supreme Court quashed everything. Now, question now appears, my lord. In the meantime, something happens because this is the two wings of the state. All councils and primary board are the wings of the state. School service commissions, West Bengal board, all are wings of the state. So, my lord, because of the state function, why a citizen, my lord, in these hard days should suffer for that? Court has obviously recorded sympathetically, but this sympathy, my lord, court doesn't have the sympathy jurisdiction. I'm also submitting, but the sympathy in the sense, in the facts of the circumstances, whether he can be considered in law. So, my lord, I am praying the similar relief because this that I only show to your lordships that 175 that I have been issued the appointment letter.
There is no doubt about it. We are not raising any
So
question.
factually there.
I have already checked up everything.
So
But what about the tainted and untainted?
Further, that requires, my lord, rather I am supporting one half of the case of the petitioner. If your lordship kindly come to the last annexure of the writ petition. That page 240, last annexure. My lord has got it. Says a letter has been issued from the Additional Secretary Government West Bengal to Commissioner of School Education. That petitioner number 1 and one of the petitioner, they directed to take steps and requested them to take a necessary action.
Well, they made the representations. Well, this is one of the salutary principles that we approach
My
first
lord,
and then come.
two things, my lord, I shall indicate before your lordship. My lord, it is true, my lord, no doubt about it that they have issued the letter of appointment in their favor. And it is also true that they have not joined their service and they are continue with the selection, they are continue with the job with 9, 10 and 11, 12, which are subsequently cancelled. My lord, regarding, my lord, thereafter, in the judgment, if your lordship, I shall only place which my learned senior
What
friend has.
happens to a candidate who subsequently in the 2016 is a tainted candidate, and so far as primary qualification is concerned, he is untainted? What is the implication of the judgment of Honorable Supreme Court in such a circumstance?
Now, I tell you, lordships, very pertinent question. My lord, so far, tainted or untainted, your lordships is raising the tainted. Tainted cannot participate in that selection process.
But at that point of time, there was no scrutiny by the board that whether he is tainted or
No, no,
untainted.
sir. When the primary appointment in 2021 was given, now, my lord, if they approach, court may not go in their favor because of the past conduct. Because the conduct is that why they were declared tainted, my lord, they were selected on the basis of blank paper. They were mismatching of marks. There were misrepresentations. That's why they have given, my lord, tainted. Very unfortunately, whether that's correct or not, they have to bear with this, my lord,
Okay. My lord,
throughout all the career.
my lord, 2-3 things I shall
So this is
indicate.
the distinction drawn by this.
My lord, may I come back? My lord,
But I will require at least a report from you.
Exactly.
my lord, two things, my lord, two things I shall indicate, my lord, regarding the selection process of Malda by which my learned senior friend has placed reliance. My lord, there is no cases is pending before the Honorable Supreme Court. And here in the South 24 Parganas, there is an SLP is pending. Even if, my lord, there is no order of status quo, but the matter is fixed on 21st January 2026 at the top of the list. Regarding the challenging thrown by the panel published in 2009. Even if your lordship has passed the similar order, we cannot issue the letter of appointment because of the matter is pending before the Honorable Supreme Court. Number 1. Number two, my lord, in paragraph number 47, which is of the Boishali judgment, which my learned senior friend has placed reliance upon, my lord, which clearly indicated the persons who are been revert back to their original post, or those persons who are not been reverted back to, and here it is specifically indicated the person who has already in job. Though my lord, that case has been learned, coordinate bench has similarly fact and circumstance, no dispute about it. But if your lordship has passed similar order, it is contrary with the direction of the Honorable Supreme Court. Clearly contrary to the Honorable Supreme Court. And my lord, I have taken an instruction. I think, my lord, a memorandum of appeal has been filed against the order of this court. My lord, for that reason, my lord, I have to take an instruction, and I shall file a report within 2 weeks. And my lord, for the benefit of the others candidate, my lord, 216 candidates, we have referred the matter to the Commissioner of School Education, and they have reverted back to their original position in the primary school, the different selection process. But those who are already in job, do have accepted the letter of offer.
Well, I submitted before lawsuits that I am doing an impetus. I have never said that your lawsuits to take reference to the Supreme Court judgment. Even the coordinate bench did not do that.
Affidavit of service filed on behalf of the petitioner is taken on record. Mr. Shubir Sannal and its senior advocate appearing for the petitioners submits that all of the petitioners were selected in the recruitment process of 2009 for assistant teacher for primary schools
Regarding South 24 Pargana.
in the district of
South
24 Parganas, South 24 Parganas. However, since the petitioners were also selected for assistant teachers of higher secondary schools, they chose not to join the service in primary schools. Assistant teachers for higher secondary schools in pertaining to the recruitment process of 2016. The recruitment process of 2016 has been struck down by the Honorable Supreme Court. However, the untainted candidates were allowed, who worked in their previous jobs, were allowed to revert back to their earlier job. The petitioner, being untainted, has filed the present writ petition seeking to revert back to their previous posting, that is, as assistant teachers of primary schools. To buttress his contention, he relies on a decision of this court passed in Karthik Pandey versus State of West Bengal and others, WPA 13514 of 2025. Mr. Swan Solan, an advocate appearing on behalf of DPSC South 24 Parganas, submits that the petitioners never joined their service as an assistant teacher in primary schools.
And my lord, regarding that order of the coordinate bench regarding the selection process of 2009.
দিয়ে দিয়েছিল জজ ও তুই অন্য কোন অর্ডার দিচ্ছিস
2009 এ।
কোন অর্ডার আমি বুঝলাম
Which is this order?
My lord, this is the selection process of 2009, SLP pending. For that reason, my lord,
What?
after the conclusion of SLP, the liberty was given to the petitioner to mention.
This is not in respect of which DPSC?
This South 24 Pargana. Same. My lord, regarding filing of report, my lord, I do not stand. But SLP is pending. For that reason,
But further informs the court that a special leave petition is pending with regard to
selection process
of 2009 in respect of South
South
24 Parganas.
and matter is fixed in 21st January at top.
And the matter is fixed before the Honorable Supreme Court on 21st of January 2026. He seeks accommodation to take appropriate instructions. Please, this matter 21st পরে date fix. আচ্ছা, ডেফিসিট কোর্ট ফিস ফাইল ই চালান ই চালান relating to deficit court fees submitted by the petitioners is taken on record.
But if they wishes, Malad, they can file a report so that your losses can also, because they wanted that. That should be.
DPSC South Supervision directed to furnish a
Not
report.
DPSC, states should also come up.
Yes, for the
As
state.
because my lord, they are-
I am for secondary board, my lord. Board
Board is-
gave appointment in 2016. State is
Who is for
required.
the state?
report from the commissioner is very much required.
Because they forwarded to the commissioner. I shall communicate it, the order of your losses.
The
And only
DPSC
commissioner-
South 24 responded DPSC South 24 Parganas as well as the state. Respondent is
School
directed to
education, rather. better.
Commissioner of School Education is directed to furnish a report on the returnable date.
So for the next matter, similar, you know, all the district. District is different, not the key আছে?
ওটা নিয়ে same order 604 and
কত?
only 604.
But here is also only difference, there is no SLP in north, only that portion should not go.
ওই SLP টা বাদ দিয়ে 21
Affidavit of service and.
Grateful, my lord.
we place it on the same date.
Yes, ma'am.
These are almost same.
Taking instructions. I do not.
My lord, before my lord rises up, I apologize for bothering your lordship like this. This matter has been assigned to your lordship specifically after it has been released by the coordinate bench. My lord, the urgency is that the matter pertains to a seat of a medical college, my lord. The stay round is going to get over on 25th. If my lord can keep the matter, I'm mentioning upon notice. Can we keep the matter to be mentioned tomorrow? It won't
No,
take
no,
much time, my lord.
After the vacation.
My lord, then I will lose the stay round, my lord. My lord, it has been released by coordinate bench. We have mentioned before the Honorable Chief Justice. Honorable Chief Justice,
Receive the
kindly,
report
I'm
after-
mentioning upon notice, my lord.
After the vacation on
My lord,
second
then
day.
my lord, it will become infructuous.
Why?
Because my lord, the stray round will get over on 25th of December, my lord. I'm mentioning upon notice, my lord. It has been specific.
Whatever be the fact, how can I take it up on tomorrow?
Can it be kept at to be mentioned, my lord? Then my lord decide, my lord will take it up before vacation or not. To be mentioned tomorrow, my lord.
No. After the vacation, come after the vacation.
The file has also reached my lord.
কোথায় দেখি?
Tip number 1. Here I come 25457.
You're not following the list. On Friday, it was listed in the supplementary list. Yes.
No, my lord, Friday they were mentioning of that. Your lordship will take the MSc matter. There was no indication.
কি বলবো বলুন?
কালকে শেষ হয়ে যাবে।
What is the fact of your case?
My lord, the petitioner is the student, my lord, who has filed this writ petition. We are the college, my lord. He has filed the writ petition seeking admission in the before the college, which I am representing you before your lordship. While my lord, while he was seeking admission, my lord, he has given a forged bond. By virtue of that, the Honorable Coordinate Bench has disposed of the writ petition, and thereafter we have filed a recalling application, which is Can 1, my lord. Can 1, because after we found that the bond was forged, we have came before this Honorable Court saying that his seats cannot be given, my lord. And pursuant to that, the Honorable Coordinate Bench has also granted, my lord, investigation by the CID, my lord. Thereafter, my lord, the stay round counseling has already, the notification has been issued, my lord, has begun also, my lord.
So what is the prayer in the writ petition?
The prayer of the writ petitioner was that that he used to get the admission. My prayer before what I am seeking with your lordship is a recalling application for cancelling his provisional admission, my lord, because he has got that admission by virtue of a forged document, my lord. And thereafter, when the Honorable, my lord, I've been led by Mr. Chakraborty, my lord.
He filed a writ petition saying that, I'll just get 2 minutes. I know it is the time to rise.
Tell me, 25th December is the last date you show me a document.
Yes. Lord, the central government has, Lord, I filed a writ petition in the Supreme Court for extension of time during the pendency of that matter, Lord.
So
The
counseling will be till 10th of January.
that is admission, last date of admission. একটা ইয়ে নেছো নিশ্চয়ই।
Counseling is till the 3rd January.
একটাই কপি আনতে হবে, আর আনা যায় না।
3rd January is the date.
No, my lord.
Sorry.
Lord,
My
kindly-
25th,
Second January pick the matter.
kindly,
18 to 30.
Lord, 18 to 25th, kindly see the second column, second box. 18 to 25th, second box, Lord. For the
Column number by
একটা
18 to
কপি দাও,
37.
একটা কপি দাও। Now kindly see, there are
It's
two
stray round.
Yes.
Special stray round.
This all stray round. It will end on, Lord, kindly come to the last column, 20th to 25th of December. So if the set, Lord, if ultimately my Lord decides in our favor, seats get cancelled, then we will get a chance to admit
Who
someone
has
else.
forged the document?
The student.
Who's the writ petitioner?
Admit that. Lord, what happened? Just give me 1 minute. Lord, our writ petition was filed. Lord, when a student gets, he got a seat in the third round of counseling. The system is that he will go to the admission center. There are several colleges. It is a state quota candidate. There are 3 types of quota: state, management, and NRI quota. But he came, he was supposed to come with a bond before the first class magistrate, an indemnity bond that, Lord, there are 9 semesters. 2 semester fee is taken in advance for, Lord, admission. 7 semester fee, he will give post-dated check and a bond saying that I will not violate any payment schedule. That's the system. That is the requirement of West Bengal MCC. He came up to court before Justice Basu saying that the college asked for a bank guarantee, which was false, and he was carrying a bond. He showed that within time. Lord, we believed him. We said, very well, if he was carrying a bond within time, provisional admission was granted. Lord, in the evening, we found there is some interpolation. I sent my junior to the office of the CJM Alipur. CJM Alipur reported that the entire bond is fake and forged. There is the seal, signature, number, the lawyer, everything is forged. We brought it to the notice of the court that he got admission on this. Court immediately stayed that admission. Admission was stayed on our recalling application. Then court directed us to lodge an FIR against him. DIG CID was directed to investigate. In between, the matter came up before Justice Basu again. Justice Basu Miller directed that he should be on 20th, that he should be provisionally admitted if he produces a fresh bond in terms of the format. But there's a format given in the website. But he on 20th produces a format which is wrong. The format requires 2 signatures of 2 guarantors. There are names of 2 guarantors given, only 1 signature was there. So we approached the court saying that kindly consider your order has again been violated. The format is wrong. But at that stage it is pending. Now today, ultimately my lords after 1 month decides that the student dismisses my application. Then he will be continuously studying. He is there. Now today, if my lord decides in my favor after a month, and his admission is cancelled, the seat will go vacant. This urgency or the situation has cropped up just
for whose reason this situation has arisen? Tell me.
For the student.
Then?
But I will
Every time,
suffer.
every time the
I will
first
suffer.
hand forged documents.
Yes.
Second time wrong format.
Yes. So
now
I
you
will
say that
suffer.
there
I am
is
the
content
college.
there, so you take up the matter.
I am the college, my lord. If my lord decides in my favor, if the seat is shown into the seat matrix of the present counseling, then my lord, we will get a chance. Someone else who is a eligible candidate can get a chance. It is not in our hand. It is through centralized computerized.
There is no order of the state. No order of stay passed in the present writ petition.
Lord, Justice Basu allowed him to be provisionally admitted on 20th of November, saying that he will, if he submits a proper format, will be admitted. He came to us 1 minute before the admission is over. We admitted him with a rider that if it is later on found the format is not there, we will proceed before the court. That is our supplementary affidavit. Lord, may I just say one thing? Instead of right now, if my lord gives it tomorrow, give me 5 minutes time. I'll try to explain. I know it is very hard placed.
Try to understand. It's not a fixing a day.
But if this is the situation is, if tomorrow my lord decides in my favor, then his seat will go. Lord, what will happen to him? I don't. But a deserving candidate will not be able to study. Now there is a chance if my lord decides in our favor, rejects the MCC, my lord, we will anyway will get the similar fees. There is nothing that we will gain. For state,
I'm not concerned of that. This
state quota, the fixer
matter where an allegation has been raised, a forged document was placed at the time of counseling.
Yes. That's the point. Lord, kindly give us 5 minutes time tomorrow. Anytime 2 p.m., 3 p.m., 3:30,
Starts
4
with
p.m.
5 minutes, but does not end with 5 minutes.
Okay, can we come tomorrow at 4?
কি করে হবে?
There will be no 3:30. I'm told minute before.
The affidavits have been filed.
Everything is fine
Everything is fine.
on the supplementary affidavit. Now,
Okay.
student is there. He has joined the courses. No, I cannot insist more, Milord. If it comments to your Lordship's diary, Milord, kindly, because a student from very beginning who is forging documents, does he deserve to study there? It is not that the college will gain anything. On the contrary, my Lord decides after some time we will lose a seat, we will lose money.
You are for?
I'm for the college, for the
Number
institution.
8 and recalling applicant.
Who is for the petitioner?
Lord, for petitioner, Mr. Mihir Saha, we have served a notice for mentioning, right?
Yes, yes.
And state and West Bengal Medical Council.
We have served everyone notice. That's what I'm told. My Lord, ultimately it may be a situation, my Lord will dismiss my application. Let that be done. If I lose, I lose, but at least there will be a clarity whether during counseling anything will happen or not.
So
Only that.
What is the stage of the criminal proceeding that has been?
Lord, I'm told one person has been arrested in connection with that, but state will apprise your Lordships. But it came into the newspaper. But I tell you, Lordships, Lord, a live streaming হচ্ছে এখন? With some,
Of course.
there is a
Okay.
Lordship, I'm for the petitioner. I'm led by Advocate Shobhusai Chatterjee. Is currently engaged in. I'm led by Advocate Shobhusai Chatterjee. Is currently engaged in court number 1. I will assist your Lordship until the leading counsel arrives.
Good. Very good.
Your Lordship, my case in a nutshell.
দীপ্ত দাশগুপ্ত আছে না বলে আসতে বলুন তো দুটো ম্যাটার ছিল কি ম্যাটার দুটো টাইপ করবো না ওটাকে একটাতে বিট করে দেবো ওকে বলেছিলাম সেপারেট হবে বিট করবো
Yes. Lordship, my case in a nutshell is that the petitioners
For addition of party.
Lordship, the petitioners through this writ petition challenges the recruitment notification dated 25/9/2025 for arbitrarily discriminating against and omitting a class of candidates who had acquired 18 months DLED from NIOS, which validity has already been upheld by the Honorable Supreme Court and as well as the NCT. If your Lordship kindly comes to the impugned notification. Lordship, the impugned notification is volume 2, in volume 2, page number 152.
দিলে হবে না দিয়ে কি লাগবে
এইটা পরের বিবিটা এখানে আনলি কেন?
The impugned notification is page number 152 in volume 2. Yes, Your Lordship, it is stated in this impugned notification the qualifications for requirement to be appointed as an assistant teacher in any primary board. Your Lordship, the qualifications stated herein is that the candidate must be a citizen of India and the candidate must have passed higher secondary or its equivalent with at least 50% marks and 2-year diploma in elementary education, higher secondary with 45% mark and 2-year diploma in elementary education. And Your Lordship, there are 3 or 4 more criteria. Your Lordship, one thing that is common in all is that the requirement of a 2-year diploma in elementary education. We are the candidates who have obtained 18 months DLED course from NIOS. Your Lordship, its validity and has been already upheld by the Honorable Supreme Court. Your Lordship, that judgment is which is given in Jaivir Singh, in the judgment of Jaivir Singh. Your Lordship, I provide Your Lordship with a copy. Lordship, the validity of 18 months DLED was challenged many times before various courts, and the Honorable Supreme Court in Jaivir Singh finally adjudicated the issue.
Yes. Paragraph.
Your Lordship, paragraph 41, page number 36. Paragraph 41, sir. The Jaivir Singh judgment again.
You get a copy.
Lordship, it is in paragraph 41. In view of what has been held by this court herein above, we find that the High Court erred in holding that 18 months diploma conducted by NOS through ODL mode is equivalent to the 2 years regular diploma. Particularly so when there was no material placed on record to even remotely hold that such a qualification was recommended by the expert body NCT. On the contrary, the communication dated 6 September 2019 of NCT, the directives of MHRD, so also the recognition order dated 22nd September 2017 clearly go on to show that, you have to kindly note this, clearly go on to show that the 18 months diploma was provided as a one-time window to the in-service teacher to acquire the minimum qualifications between 2017 Amendment Act of the RT Act and the outer limit of 1st April 2019. Therefore, it was given as a one-time window to get the 18 months diploma in order to comply with the amendments made in the RTI Act. Your Lordship, clarifying this judgment, the Honorable Supreme Court passed another order in Kaushik Das. This stand was furthermore clarified. Your Lordship, the Kaushik Das judgment is annexed in page number 247 of the writ petition. The relevant portion is there. 247 of the writ petition, volume 2. Lordship, in page number 247, paragraph number 40, subpara 5. We clarify that such of the teachers who were in employment as on 10th August 2017 and who completed the 18 months DLED ODL program through NIOS before 1st April 2019 shall be considered as valid diploma holders for the purpose of applying in other institution and for promotional purpose. Your Lordship, therefore, two conditions are set out by the Honorable Supreme Court in this matter, that the teachers who were in employment as on 10th August 2017 and who had completed the 18 months who had completed 18 months DLED program through NIOS before 1st April 2019. These are the two conditions set by the Honorable Supreme Court, which will...
you qualify this?
Yes, Your Lordship, I qualify this.
Yes. Now about the CAN application.
CAN application, my lord, we have received the copy. This is has been filed and on behalf of a set of candidates who are claiming that
Do you intend to
their rights may be hampered.
file any opposition to the CAN application or allow them to make their submissions whatever they like?
No, we are opposing this. But Lordship, I would only demonstrate this CAN application will have possibly no effect on the adjudication of this writ petition.
To that event, then the CAN application be allowed because it will have no implication. I shall only make submissions when my lord hears the application, the writ petition in its final hearing.
That can be if they want, because we are today for an interim order. On the basis of the Honorable Supreme Court judgments, we want a clarification from the board. Let us be permitted to participate in the ongoing process in view of the Supreme Court judgment, where Supreme Court had allowed this one-time window for the in-service teachers. My case is that all the petitioners, they are falling within this square, that they are one-time window to the in-service teachers. They were in service. But you kindly take this on contrary to the communication that is 6 September, the directives of MHRD. So also the recognition order dated 22nd September 2017.
Which paragraph
clearly,
you have stated?
My lord, paragraph 41 of JVC.
Well, that I have seen.
Yes.
In which paragraph you have stated that you are in service on
My
such
lord,
and such
in my
date?
petition, my lord?
Yes.
Yes, my lord, it's in, it should be in P1, annexure P1, it is in, but you kindly come to paragraph 4. Petitioners are aspiring candidates seeking to participate.
No. That two conditions, that on 10th of August 2017 you are in service.
Yes.
And within such and such period, 1st April 2019, you have completed the 18 months DLA.
Well, so far the 17 is concerned, it is there. Paragraph 4. Your petitioner states that petitioners are aspiring candidates seeking to participate recruitment process in such and such. That is submitted that the petitioners have completed their DLED course of 18 months from NIOS in the session 2017 to 19. It is further to be noted that the petitioners before opting for the DLED course were in course of the employment in various schools, all of which falls under the purview of the definition schools.
What I am on is, the clarificatory order says that
two conditions.
Yes.
Both.
Now you cannot say, where is that? Where is
Yes,
that documents or where is the averments?
Yes, averments is there that petitioners have completed their DLED course of 18 months from NIOS in the session 2017 to 19. In paragraph 4, last line, the petitioners were in service in such schools as on 10/8/2017 and have continued to do so since then.
Okay.
So both the lines are there in my amendment. And so far the addition of party is concerned, I agree with Mr. Chaturvedi that if they do not want to come on the way of granting any interim order, I'm fine. If they want to place those things, then I'll have to oppose it. But if otherwise, I do not have any objection if they are permitted ultimately to continue and contest it for the finality.
Okay.
Before I am misunderstood, but I say that the learned friend is submitting that our addition will have no implication insofar as adjudication of the repetition is concerned. So I say that means that my application goes uncontested, will be added. After that, when he is making submission, if any of his submissions or prayers, Lord, it comment to us that it requires to be opposed, whether at interim stage or at final stage. As a party respondent, we will have always the liberty reserved, subject to my Lord's kind sanction, to oppose such prayer.
Okay. In that event, you have made your submissions. That is.
Yes, that is my submission, my lord. Now it's up
What
to
is
them.
the other aspects or merits of this?
That can be decided in final.
Why we finally dispose of the writ petition? If that is the
This is the aspect.
your
It's the only
grievance
aspect
is
for which
that
we are before you.
since in service, as per the Honorable Supreme Court's order, you have satisfied
We
both
satisfy both the conditions.
you be allowed to participate in. This is a writ petition. Yes. We allow the CAN application. Asun. আচ্ছা এটা পিসমিল না করে শুনে নি তারপর অর্ডার করে দেবো ইয়েস মিস্টার চতুর্বেদী ও মিস্টার সান্নাল will submit for the board.
My lord, my lord, we have taken your lordships to the in the other matters. These sort of matters, my lord, had generated from the change of law. Change of law in the sense, my lord, when the NCT became the academic authority under the Act, NCT Act, read with Right to Education Act. And this started from, my lord, 2010. Your losses kindly remember we have in other matters placed before losses 2010 notification
23rd August
23rd that the laying down the minimum qualification which was little amended in 2011.
Yes.
Now your lordships kindly also recollect your lordships that TED guideline. Now, my lord, we will take to the Right to Education Act, your lordships. I will take the documents also in the writ petition. My lord, even if a candidate or a person is appointed as assistant teacher in any primary school, after coming into force of the TED guideline and the recruitment notification, whatever your lordships, TED guideline, one has to be trained and other was your lordships TED qualified. Initially, training was relaxed, but that relaxation was only a lordships in respect of aided schools or government schools. So for primary, my lord, private recognized schools, my lord, there was no such relaxation. Now, your lordships, I will not stick so much to that relaxation was not even to the private school. Your lordship presume that for the time being, though I am not leaving that argument, that relaxation was also applicable to the recognized private school. Other way we say self-finance schools. All the petitioners are claiming to be the assistant teacher in private schools. I do not find any averment in the writ petition that those schools were recognized schools. Supreme Court order will come up subsequently. Supreme Court laid down the law that if you completed 18 months, my lord, course while you are in service in private schools, you are entitled to be at par with the 2 years DLED course as a one-time benefit. Because that was one-time benefit. I will take your losses to that. Now, before that, your losses kindly take up the definition of the school. Your losses have the spiral binding, your losses. Yes. Everything will appear from the writ petition except pleadings. School 35. Now, my lord, page 35, the act, my lord, the starts. Now, my lord, I take your lordships to the definition 2 small n. I just read out to your lordships the definition clause. School means any recognized school. Your lordships got it, page 35 start, page 36. School means any recognized school imparting elementary education. My lord, here recognized school. I will take to your lordships to that. Includes number 1, a school established, owned or controlled by the appropriate government or local authority. 2, an aided school receiving aid or grants to meet whole or part of its expenses from the appropriate government or the local authority. So, my lord, 1 and 2 are almost overlapping. My lord, it's aided, virtually owned. A school owned by the government means fully aided under the grant in aid scheme. Number 3, a school belonging to a specified category. And 4, an unaided school. That means private school, not receiving any kind of aid or grants to meet its expenses from the appropriate government or the local authority. So, my lord, the subclause 4 has to be read with the starting line of the definition, any recognized school. So, this unaided school must be recognized, your lordships. These are inclusive definitions. Means any recognized school. Suppose, like a mushroom, a school is there in one ground floor in one of the building, a private ownership runs without any recognition. And if someone gets on the basis of that appointment letter and 18 months ODL course, Lord, I am putting a question to myself, would he be proper? Or this is an act of fraud on the part of the authorities, on the authorities rather, over the authorities. I will show to your lordships the documents, all this. Now, your lordships, taking advantage of one thing and another, your lordships. I take your lordships to the, just your lordships, the other sections. Okay, dekhe rakhlam. Section 18 at page 40. No school to be established without obtaining certificate of recognition. Kindly look at this. Subsection 1. No school other than a school established, owned or controlled by the appropriate government or the local authority shall, after the commencement of this act, be established or function without obtaining a certificate of recognition from such authority and by making an application in such form and manner as may be prescribed. So there must be a recognized school, maybe unaided. There are several schools, your lordships, to completely out. Now, we give an example to your lordships. South Point School. All throughout unaided, but recognized by the CBSE, by the board, West Bengal board. For a very small spell of period, it received grant. As soon as it received grant, government imposed upon its teachers. Then they say, "Map, I will not receive your grant. Because whatever you impose upon me, I am not ready to accept." They leave it. I am giving an example. What sort of schools are there? This is recognition. There must be a certificate of recognition by the state government. Now, your lordships, I go one by one. Take up, my lord, page 103. This is one of the appointment letter of the petitioners. My lord, I am not aware on what basis they got the admission in their 18 months course. Might be this, might be different, because I was not the authority. Page 103. Kindly see your lordship. Shanirvar Shikha Niketan. Your lordships will find organized by Canning Shanirvar, registered number 573 such and such dated such and such Government of West Bengal. This registration, if I'm not absolutely wrong, relates to registration under the Societies Registration Act. A stands for society. If I'm not wrong, my learned friend will clarify it. Then FCRA registered number, Minister of Home Affairs, all that. But what is the recognition under the Act? And kindly have a look at your lordships. All these recognitions prior to your lordships coming into force of the Right to Education Act. All these registrations. One is 88, another is 91. This, your lordships, Act came into force in, if I'm not wrong, your lordships, and just your page 35, I give your lordships the date. In 26 August 2009, your lordships will get that from page 35 of the spiral binding. RT Act, my lord, ultimately effect was given, my lord, in 2010, 16th February. At the bottom, your lordships will get it. By notification dated such and such. At the bottom, number 1, your lordships will get it. So all these registration, not even recognition, under the different acts, your lordships, prior to this act, they cannot, there was no such recognition process like that. After this act, no person is entitled to run a private school without the recognition. The logic is that government must have a control on the system of education. What you are teaching to the school, what is your standard? Because you are collecting money from the parents. You are not paying from out of your pocket. So government must have a control to every recognized school. That's why recognition clause. In respect of unaided even. Aided must be. So, my lord, what I'm trying to impress upon your lordships, I will show other things also. That how this was done, the appointment.
Yes.
Now, this is an appointment letter. Your lordships kindly have a look at the date, page 1036, 26. I'm একটু সময় নেব তুই 26 December 2014, page 103. I give an example because all of them like this. Now your lordships kindly have a look at the contents of this. I am pleased to inform you that you have been appointed for the role of assistant teacher in our institution. This is an official letter confirming your employment with Shonirbhar Shiksha Niketan starting on 3rd January 2015. Well, kindly mark date. 15. The appointment, then another appointment, I don't know. The appointment of Kisholoy Noskar is on temporary basis. And then you're subject to the terms, all that. Now, my lord, I take your losses to date, appointment letter date, and my lord, starting from date. I will take your losses to the Supreme Court judgment when the Supreme Court has narrated the history of this 18 months old way. My lord, this started from this date. What I'm on, that these sort of appointments have all been made after this process started, so that they can, on the basis of in-service teacher, get the 18 months DLED. Because otherwise competition is there. You have to go to the market to compete with thousands of students and then get you selected. But if you can show I am in service, you will permit it to 18 months. So this is a fraud on that.
Okay.
Then now all are unrecognized. Now your lordships kindly will look at this page 104. Shankashwar Barman, that at appointment letter Shankashwar Barman. Just your lordships kindly let me read it. 28th August 2005, this certificate is issued. This is to certify that such and such has been working, my lord. Present continuous tense, my lord. In the form eto to eto. But how could it be? Therefore, after 19th, he didn't work. He is sincere and continually satisfied with his service. Kindly see only from 15 to 19. If I take your losses Supreme Court judgment, everything happened during this period. So this appointment letter was issued to show that he is an in-service candidate and so that he can pursue 18 years. So, they have to satisfy. Now, I am satisfying your lordships. They kindly see their conduct. Now, how they did this decree. Now, your lordships, page 107. Kindly see, this is Lal Bahadur Shastri Samarak Bengali Hindi High School. Where is the registration? I am putting a question to myself. Recognition. Every school, if this is said, this is recognized REGD number such and such. But kindly request them to produce that recognition letter of these schools. Then your losses kindly see, he is a contractual teacher of 2011 of classes 5 to 8 Hindi medium and political science. We are concerned with primary teacher 1 to 5. Political science is not at all a subject, my lord. Someone goes on this basis and they 18 months, which is one time for those who are really in service. Then your losses will get it. 108, the appointment letter. I am not taking your losses to that. 111. Only one appointment letter, my lord, I have got the salary. None of the appointment letters, your lordships will find salary. No salary sheet annexed. No requisition slip annexed that they used to get salary. It's it's like a certificate issued character. Because they are not paid. Let them produce their bank account showing that they have received the salary for the entire period. Only this appointment letter, I am showing this because, my lord, I got it only in one appointment letter, at least mentioned the salary 4,000, but unrecognized. Again.
Yes.
Now, just take your lordships, the pagination number, page number 112, 119, 123, 124. Like this, 127, 128. These are all like these appointment letters. I have gone through, I am not taking your losses, wasting your losses time also. But two more I will show to your losses again. 115 and 116. I don't know, whether their certificate should be called back or not. This is 115, higher secondary school. 12th class. By the direction of the managing committee, inform you that you have been appointed as computer teacher of the school. In the primary section, there is no computer business.
Yes.
Does it? I don't know whether their submission will be to this extent. Wherever I work as a teacher, I can get it. DLED. DLED only for your losses, those qualified teachers. They have all appointed, if I'm not wrong, after 2010, Right to Education Act, 2010 NCT notification. Even the private school cannot appointment without securing 50% marks of the candidates. What are those appointments? Clear to your lordships? There is no distinction in respect of qualification of the teachers. If you want to get your job in the aided school, you have to compete. But if you want to get a private school, you are merely go and do that. But you have to satisfy those conditions. These were not before the Supreme Court. Because Supreme Court was on the point of law. Whether 18 months course, who did it as an in-service teacher, whether they can be considered in the subsequent process or not. Supreme Court says, initially said no, it's not equivalent, I will take your lordships, subsequently modified. So my submissions, your lordships, on these sort of appointment letters, they secured the completion of that course, which they otherwise not entitled. Now kindly see 116. This is of 2005 certificate. That Niranjan Rai, 115, his appointment letter and experience certificate, kindly see. This is to certify Niranjan Roy, such and such of Alipurduar, has been working in the post of normal section as a contractual computer teacher of such and such high school. Till date, he is performing the task seriously, sincerely, and satisfactorily. There is no averment in the petition, nor does it appear from any of the documents whether they are higher secondary pass or not. Even a non-matric can do very well do computer functioning. What sort of qualification? Did you get the 50% marks in higher secondary examination? No qualification mentioned. So it's if someone gets a computer trained person without any qualification and they get 1,000, 2,000 rupees or 3,000, obviously private bodies to the private institution lucrative because they are getting the job. But that's not the standard of education, Mala. And entire thing your losses will find, and there is no contractual teacher. And then Malad 119. Siliguri Public Co-ed School, no recognition. None of the school, your lordships, their letterhead says they are recognized. Kindly see the appointment date, 26 June 2017. Your losses, the 2 years gap, your losses, kindly remember from August 2017 to July 2019, if I'm not wrong. When the appointment secured?
Yes.
From an unrecognized school, completed as in-service teacher. Now I take your lordships to this notification. আমার কাছে নেই এটা তো আমাদের গাইডলাইনও আছে এখানে kindly have a look at this Ministry of Human Resources guidelines. I have certain submissions. This is of 8 November 2010. Guidelines under section 35 of the Right to Free Education Compulsory Act for implementation of the provisions of section 23G. This has been issued by MHIT, the nodal department of the central government. National Council for Teacher Education has, in exercise of the powers conferred by section 23(1), laid down the minimum qualifications for a person to be eligible for appointment as a teacher in schools, via notification dated 23rd August 2010. This notification has already been circulated to the state government and the other authorities. The notification can also be downloaded from the website. Accordingly, all appointments of teachers, kindly consider your losses, in classes 1 to 8, in respect of all schools referred to in clause N of section 2, I have taken your losses to that because of this, have to be made in accordance with this notification. That's why I'm harping before your lordships. Even in the private school, if you are a recognized school, you are coming under the 2N. First of all, you are not coming under 2N because these are unrecognized. If they can show, that's another issue. I do not find from the pleading or from any document. Secondly, even if you are recognized, you have to comply 23rd August 2010. That means higher secondary, your lordships, 50% marks and 2-year diploma. That was relaxed, your lordships. But what not relaxed, I will take your lordships to that. Lord, your lordships will find in 23rd August 2010 notification, I need not place it, your lordships. State is a must. Now, your lordships, of this notification, I handed up clause 4. The condition of passing TET will not be relaxed by the central government. So one cannot be appointed even in unaided private recognized school without TET. You cannot. That's why, your lordships, TET, the certificate is valid for indefinite period, for whole life. Why? If you cannot secure an appointment in aided school government job, you can do it with this qualification in private schools. So this was not relaxed. But what is their case before your lordships? In 2017, as in-service teacher, I'm sorry.
Yes.
And in 2017, as in-service teacher, they admitted themselves in the course, and 2019. But when they got the TET pass, Mala, that your lordships, all are TET pass in 2022. Page 122, your lordships, kindly. One of the certificate.
Others have not passed.
Mala, all pass 2022. One I am showing to your lordship, they have annexed. Probably they have annexed others also. Not all. 2022, Malan, I am on what? On clause 4. So when you are appointed without passing TET, how could you be appointed? It's an illegal appointment. Even the school is recognized. Because you did not qualify, fulfill the conditions of NCT of 2010. So without TET, you are in service teacher, which you could not be. Now, Malad, law is as of today after 2010 August, even in recognized private school, authority cannot appoint a teacher without compliance of 23rd August 2010 in primary schools. Malad, we are not, Malad, we are duped. We are duped by the authorities because we do not know, Malad, most of our children are in the private sector. We do not know how many of them have TET pass. This is an illegality. But court cannot be a mute spectator to this. You cannot get the reap of the benefit on the basis of your illegalities.
As per the averments in the writ petition, they are all past date 2022 or
Exactly, 2022. So they could not sit for school. The authorities did not verify all this. This was not the case either before the Honorable Supreme Court. Supreme Court issue was only whether those who passed DLED in 18 months as in service, whether they can be allowed to participate in the next recruitment process. Ultimately, issue was that whether this is at all a qualification for the recruitment purpose. Initially said, my lord, in Jaibi Singh, no. I will take your lordships. So for the factual background is, these are the factual.
As per you, before the Honorable Supreme Court, the other conditions were satisfied by the petitioners before the Honorable Supreme Court.
I am not sure in that.
না না না
I'm
সেটা নয়, তার কারণ হচ্ছে আমাদের ওইখানে যে অর্ডারটা ছিল আমরা 30-5 এই যে এইটা দিয়েছিলাম না,
No, that's your lordships. I will clarify that. That was not there. And that was, my lord, not before the Supreme Court also. We have clarified that. And today I have come to know that in 2022 selection process, we wanted to verify all these and issued a notification. They questioned it before the Supreme Court, relying upon Kaushik Chand judgment. So probably they have withdrawn it today. I have got the judgment, seen the judgment today. I will show to that. So our requirements, my lord, as today, my lord, that's valid what we are asked. But we are, that's a 2020 selection process. That was during the pendency. But this is, my lord, just to have started. They have to satisfy your lordships. Or the petition will show. Why should I allow a candidate, my lord, who doesn't fulfill the conditions? Prima facie. His document shows that he is not entitled to the benefit of 18 months courses.
Yes.
Now, your lordships, I take your lordships to the JIBC judgment.
কোনটা
ওই যেটা আজকে হলো দেখলাম একটা কোথায় হয়েছে না উইথড্র করে নিয়েছে কবে দেখলাম আজকে ও আচ্ছা সেটা আমি দেখাবো Now your lordships have been shown the main judgment of JB Singh of dated 28th November 2023. I just take your lordships to that judgment. না এটা তো JB Singh এর মেইন জাজমেন্টটা কই
এটাই তো মেইন জাজমেন্ট
23 আগস্ট কি
হ্যাঁ
স্যার এই নেবেন এই কপি নেবেন
না দেখছি
এটা রিপোর্টেড কপি দেখি তোদের কি কপি আছে রিপোর্টেড কপি এটা
না এখানে তো হোল্ড করলো যে
Paragraph 41. of the-
For matlab the paragraph where because online matlab and another এটা কি জসিম প্যারাগ্রাফ 41
দেব
দেখি হ্যাঁ জসিমকে দিয়েছে ওরা
The paragraph where Ram Saran Maura has been quoted, just
প্যারাগ্রাফ
before, where Ram Saran Maura has been
আচ্ছা জাস্ট
discussed, just prior to that paragraph.
এইটাতে আমি দেখিয়ে দিচ্ছি এইটা দেখিয়ে চল 56 প্যারাগ্রাফ 56 ওরা দেখিয়েছে
না
41 দশ সাহেবের ওখানে 41 প্যারাগ্রাফ দেখিয়েছে যেটা এখানে আমাদের এটাতে
না মিলছে না তো এখানে
এইটা আমাদেরটাই মিলছে
ইন ভিউ অফ
হ্যাঁ এইটা ওরা দেখিয়েছে কিন্তু আপনাকে তার আগে থেকে দেখাতে
হ্যাঁ না কোথায় যেন হোল্ড করলো দুটো ইকুইভ্যালেন্ট নয়
হোল্ড করলো
Para 41. Para 41 last.
মানে that paragraph I'm noting is different মানে your loss is paragraph 41 এইটাই তুমি দিয়েছো তো
না
না না
তোমারটা
রিপোর্টে দিয়েছে
হ্যাঁ
এটা আনরিপোর্টেড এটা
আর জজ সাহেবের কাছে এটা আছে তো
হ্যাঁ, এটা
সেটার জন্যই তো আমি চাইছি জজ সাহেবকে কি করে অ্যাসিস্ট করবো Now, paragraph 41. In view of what has been held by this court herein above, we find that the High Court erred in holding that 18 months diploma conducted by NIOS through ODL mode is equivalent to the 2 years regular diploma. Initially, court held this. This is not equivalent. You cannot do that. Then the question come up, your lordships will find page 208. Your lordships kindly come. Here I will show your lordships certain things. Page 208, it starts Vishwanath versus Uttarakhand. That judgment. This is order dated or judgment dated 5th March 2025. This was, if I am not wrong, under review.
Yes.
Now I will be placing some of the paragraphs of it. Why I am saying all this factually I had taken to your losses. To paragraph page 209, paragraph 3. In 2017,
Paragraph
3 at page 209. Kindly see the dates are almost coinciding with their appointment letters, all that. In 2007, an amendment had been carried out to the Right of Children Education Act 2009, by which clause 2 was inserted in section 23 of the act. The Right to Free and Education Act 2017 was made retrospectively applicable from 31st March 2005. Pause here for a moment. I had taken your losses to the sum of the letters of 2015. Why? Because of this. They obtained it subsequently. It's a private school. No preparation of documents required. On the letterhead, issue the appointment letter with a retrospective date. To cover up this gap and show that I am in service teacher, I will show that, your losses. It was provided that every teacher who had been appointed or was in service on 31st March 2005. 15, I'm sorry, 15. But did not possess the minimum qualification of 2 years as laid down on subsection of section 23 would acquire such minimum qualifications within a period of 4 years from the date of commencement of the Act of 2017. Therefore, what happens to your lordships? If you are in service teacher on 31st March 2015, you have to complete it within a period of 4 years. But that amendment came into effect of 2017. So what actually happened if really a bona fide teacher is there? Because of retrospective effect, he lost 2 years. Clear to your lordships? Out of 4, he gets only 2 years more. Because of this, MHRD by notification of 2019 extended 2 years more for them. But what happens here, I will take your losses to judgment. Kindly visualize their appointment letters. All of them secured. Somebody more intellectual, they got it 2014. Somebody just give me before that to show that I am on service on 31st March. Nobody is there to check up these records. Because this was an ODL method. 18 months course, it's not a regular course. Got the one-time benefit, showing you in service teacher. But what else could be a fraudulent act on the part of these petitioners? just to take the swallow the benefit of someone else's. You could have completed in the regular course. To avoid this, you have done this. Now see your lordships. 4. In view of the provisions of the second proviso to subsection 2 of section 3 of the Act, Ministry of Human Resource Development had issued a letter on 3rd August 2017 to all the secretaries of the state and union territories, directing that all the teachers in government school must possess minimum qualifications as mandated under the RT Act, and the last chance being given to all such teachers to acquire minimum qualifications till 31st March 2019. I said it because of this, MHRD extended 2 years more, because Act was given a retrospective effect.
Yes.
So they lost bona fide teachers, if anyone, they lost. That's why then. Next, then kindly see paragraph 5. Since the time gap between 31st March 2015, as provided in the 2017 Amendment Act, and 31st March 2019, as specified in the direction issued by the MHRD, was 18 months. The NCT issued a recognition order dated 22nd September for conducting DLED program through word mode by NIOS through SAM portal of MHRD for in-service untrained teachers at elementary level working in the government unaided and unaided private schools. So what I am allowed, this is only for training qualifications. Very paragraph 4, your lordships, only those who are possessing the other qualifications. Your lordships getting it in the paragraph 4, last 2 lines in the page 209, directing, last 3 lines, directing that all the teachers in government schools must possess minimum qualifications add under the RT Act, and there's a last chance. Government schools, my lord, here later clarified that unaided private school also. But no clarification is needed because section 2N, you were covered by that. How could you ignore the notification of the NCT? Because you are governed by NCT also. Now, here, your lordships, what the court said, your lordships, kindly have a look at this. Kindly have running page 214. This is from Uttarakhand. Whatever, my lord, I will, my lord, the judgment appears, I have to accept it. Now, kindly have a look. My lord, paragraph 15. The grievance of the applicants herein is that, though they are eligible as per the original judgment of this court dated 28 November 23 and the clarification dated 10 December 2024, in as much as the advertisement in the state of Uttarakhand dated 29th May 24, that is after the judgment was delivered on 28th November 2023, the state of Uttarakhand is not considering their claim. Here, my lord, there was an interlocutory order. Your lordships will get it, that in paragraph 20 of this judgment in next page. Why I am placing it? That might be they satisfied, they are qualified otherwise in service, all that. But that was not the scrutiny before the Honorable Court.
Yes.
We are before the first court of the Honorable High Court. So we are showing before losses they are not eligible to undergo the 18 months course. Now, your losses kindly come to pay paragraph 20. No doubt that this court has upheld 2012 rules framed by the state government by the judgment dated 28 November 2023. However, at the same time, this court had clarified that such of the teachers who were already in employment as on 10th August 2017 would be entitled to benefit of one-time scheme provided by the government of India. This court had held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or promotional avenues. Paragraph 21 is relevant, my lord, because, sorry, my lord, indisputably, the other institution would also include the schools run by the state government. Now, what they are now trying? In a backdoor process, you have secured 18 months course degree or diploma. Now you are asking this benefit of this. Allow me to appear like 2 years courses. This is a fraud, my lord. Why the genuine candidate will be defrauded by the authorities? He has taken a regular course, not by any ODL mode. This is a one-time benefit given to a really bona fide in-service teachers. Then, my lord, what happened? In another judgment which relates to our primary board, my lord, that's your lordship's Kaushik Chand, page 220. কৌশিক দা হলো কৌশিক দা কৌশিক চৌধুরী বলেছি sorry no Kaushik Das. No, here I tell you losses one fact. When all these happening before the Supreme Court, 2022 recruitment started. You will see initial judgment as I placed below 23. So we didn't allow any NYS. Oh, sorry. Yeah. We initially allowed. Some of them moved the Honorable High Court. Look, this is the judgment. Initially allowed 2022 NIOS. Because in service, the court directed the Jaivis Singh judgment. You cannot, because this is not equivalent. We did not allow them. They moved the Supreme Court. Initially lost before the High Court, before the division bench also, then Supreme Court. What the Supreme Court said, your lordships kindly see. Paragraph 31 to 40, but precisely paragraph 40, Roman 5 and Roman 6. Your lordships kindly take note of this. Paragraphs 31 to 40, precisely paragraph 40, Roman 5 and Roman 6.
23
That's it. And your losses will get in paragraph 223,
page 223.
Page 223, paragraph 4.6. Your losses will get the facts. But I narrated before your losses need not travel to your losses to that extent. I take your losses paragraph 32. It's, my lord, original judgment gets modified. Now, my officers, my lord, ask me, you tell me as a lawyer whether the original judgment of Jaivis Singh is still valid after these orders. Because Jaivis Singh, your losses said this is not equivalent. Then subsequently says it should be treated at par. Those who are in service and course, my lord, 18, one-time benefit. To that extent, my lord, the original judgment gets modified. Obviously. Now, your losses kindly see paragraph 32. It can therefore be seen that even though the learned single judge of the High Court placed reliance on paragraph 56 of the judgment of this court in the case of Jaivis Singh, it came to the wrong conclusion in as much it put a blanket ban on all teachers holding 18 months of DLED through NIOS. Malad, what is a blanket ban? That means, Malad, what we understood. Our single judge, Public Justice Mantha, dismissed, allowed the writ petition and directed the council, don't allow them because Supreme Court says not equivalent. Then review came up, Malad, in Vishwanath. And then, Malad, this Kaushik. That means the Supreme Court says, rather, Malad, the views is that I have to cross-check up during the pendency. Those allowed, Malad, applied as NOIS, I have to see them whether really they are in service or not. Kindly see, put a blanket ban on all teachers holding 18 months. There might be bona fide teachers, there might not be, which I am saying they are not bona fide. So it is an over exercise on the part of a recruiting body to qualify, scrutinize, examine them whether they were properly get it done or not. Otherwise, my lord, the bona fide candidates will be deprived. Now your losses will find 31 to 40, I said your losses. Kindly come to page 247. Both the judgment and order of the learned single judge and division bench are quashed and set aside by Supreme Court. Then your losses, page 247. Kindly see, Roman 5 and Roman 6. We clarify that such of the teachers who were in employment as on 10th August 2017 and who completed the 18 months DLED program through NIOS before 1st April 2019 shall be considered as a valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Then we direct the respondent authorities to consider the candidature of such applicants who were in service on 10th August 2017 and that who on verification are found to satisfy the eligibility criteria shall be appointed within a period of 3 months from today. Now, if we read together 32, paragraph 40, Roman 5 and 6, in the pending recruitment process of 2022, we have to scrutinize them. Really, they are bona fide teachers or not. And following that, because of this, my lord, we issued a notification of 30th May 2005.
না এখন অব্দি কেউ দেখাতে পারে না।
No, kindly have a look up this notification. ওকেও তো একটা কপি দিয়ে দেওয়া উচিত না? আচ্ছা, ক্যানে আছে তোদের? Malad, then you just take the can. I don't know. I told my junior to bring 2-3 copies always.
65.
Your losses will get it 65 also. Malad, Kaushik Das's judgment, Malad, kindly take note of 4th April 2025. And this is 30th May. We have quoted that. In compliance with the judgment of the Honorable Supreme Court passed on such and such in respect of such and such. Appeal number. In compliance with the judgment of the Honorable on 4th April 2005 in civil appeal number such and such, has arranged a hearing for the verification of eligibility of the appellants on and from 1995. The appellants of the above mentioned petitions are hereby requested to attend the office of the West Bengal Board as per the enclosed schedule of time on 9th June to 18th June with the photocopies of all the documents. What we asked for, your lordships, kindly have a look at this. List of testimonial documents, mark sheet, certificate of Madhyamik Parikha and higher secondary. We have to satisfy your lordships that any valid document put of date of birth, state pass certificate on or before 10th August 2017. Because state was mandatory. Even if you engage yourself in unrecognized private. So that's why we asked for. Now, papers related to proof of in-service. Kindly see the second column. 4th, papers related to proof of in-service as on 10th August 2007, namely appointment letter, accepted joining report of the appellants. Certificate issued by the school authority specifying the service of the appellant in the school on such and such. NOC cum registration certificate in favor of the school as on. And then salary statement. Nobody will be able to show your losses this because they are never appointed. Let them produce their bank account.
Yes.
Now, Malad, fortunately, in this up to Malad, pursuance of this notification of following 22 in respect of 22 selection process, none of the candidates attended. None of the candidates produced the documents.
90%
And according to our oral instructions, 90% of the schools didn't exist even. Now, what happened, your lordships? Instead of complying with this, the state will move the Honorable Supreme Court, if I am not wrong. Judgment wrong. That Kaushik Das. And now they have on 21st July 2005, they have withdrawn the petition from the Supreme Court. They questioned this 30th May 2005. And they withdraw it.
Yes.
Now, your lordship, therefore, this notification in respect of 2022 selection process stands. Withdrawal means you are not questioning this even before the Supreme Court. So this stands. My lord, this was in view of the Kaushik Das's judgment in the pending matter. Now we are in a process of 2015 September 2025. So you have to satisfy first. What their prayer, your losses, can have a look at it. They are asking to modify the recruitment process, the notification. Page ta koto bolo in notification. Page 97, prayer, your losses. Recruitment notification.
Recruitment 2025.
Lord, kindly see prayer B, only this prayer. To modify and amend the impugned recruitment notification issued by the board by the memo dated 25th September 2005, to the extent that it includes and recognizes the petitioner's candidates, that should be our candidates, who had completed 18 months DLED course conducted by NOS, were in employment as eligible candidates. Now, my lord, I said, my lord, what my recruitment process, NCTE guidelines. So I have to read it now, Supreme Court NIOS order. J.B. Singh or your lordships, the other two, the modified, Vishwanath and your lordship Kaushik. Now you have to satisfy the honorable court that you got this like. Or let them produce all the documents before your lordships by way of supplementary affidavit. Scrutinize, we will scrutinize that. But we cannot allow them to participate like this. Anybody and everybody, because I tell your lordships, I'm a statutory authority. If someone complies with the conditions, all are equal to me. All. I cannot pick and choose. But I have to be satisfied before issuing the process that you are really qualified and genuine candidate. Why a process should be sent to a mess? It will be just like a mess, your lordships. Everybody is coming with a certificate. They do not satisfy the conditions. They were not appointed without any TET.
Yes.
So, they are therefore, your lordships, not being a bona fide in-service teachers, they cannot seek the benefit of Vishwanath and Kaushik Das's judgment. Vishwanath versus Uttarakhand on dated 5th March 2005 and Kaushik Das's judgment dated May 5th to 2025. These are my humble submissions.
23rd August 2010
Minimum
eligibility criteria.
That's the loss. I did not. 23rd August 2010, your lordships knows the minimum qualities. State must be. Yes, sir. Spiral binding. State must be there. Admittedly, 2020. These are my humble. But I just take leave and come back.
Now, to start, I'm sorry.
Yes.
Now, to start with.
How many applicants are there?
There are 4 applicants.
They will be respondent numbers?
8, 9, 10, and 11.
Yes.
Now, the prescription of an eligibility criteria, that it has a significant public law element in deciding the competing claims of eligible candidates.
Yes. Yes.
And my lord, selection of an ineligible candidate, it permits him to gain access to scarce public resources. undeservingly. Lord, the other day, my lord, I cited an example of there being only one piece of loaf available to eligible candidates. If an ineligible candidate he is permitted to enter into the zone of consideration, he is going to take a pie out of that loaf undeservingly.
Yes.
But this lot has two consequences. But one, that the right of an eligible candidate is violated. But secondly, illegality is perpetrated by bestowing benefit upon an impostor who masquerades as an eligible candidate.
Yes.
But I draw inspiration from the submissions of Mr. Sanyal that the petitioners before my lord misrepresented themselves to be in-service candidates in gaining admission to the 18 months day-late course. The question is, Lord, whether the fruits of fraud can be permitted to be saved or any equity can be claimed, Lord, qua this fraud. Lord, I gain inspiration, Lord, from the well-known principle that fraud and equity do not dwell together. Lord, kindly sees, Lord, takes up my application, Lord, page 55, this has been shown to my lord. Lord, this is, Lord, 3rd August 2017.
Yeah.
And this is, Lord, as a sequel, Lord, to the adjudication. And this is, Lord, issued by the NCTE. Lord, kindly sees the next page, Lord, page 56. The timelines along with key, my lord has very kindly got it, along with key milestones to ensure the training of all in-service untrained teachers is completed by 31st March 2019 are detailed in the table below. Lord, kindly sees 10th August 2017, appointment of nodal officer by every state and union territory. Then again, 10th August 2017, development of a dedicated portal by NIOS. And my lord kindly sees that this date, 10th August 2017, my lord, is the date which has been treated to be the cutoff date. My lord, to presume that all the competing claims in terms of the order passed in Jaivir Singh, my lord, they get a recognition in, my lord, the notification issued by the board on the 30th of May 2025, which my lord would very kindly get at page 55. 65. Lord, kindly sees, Lord, this is 30th of May 2025. Lord, kindly sees the list of testimonials. Lord, kindly sees the third requirement, TET pass certificate on or before 10th August 2017. Now, this 10th August 2017, Lord, is no magical date. This is in conformity to the guidelines issued by the academic authority under the Lord, RTE Act.
Yes.
Now, Lord, kindly, Lord, takes up, Lord, this short list of dates, Lord, this will Lord, assist your lordships, my lord, in gaining the placement of the relevant documents, my lord, in the records before my lord. Lord, my lord knows, my lord, 23rd August 2010 and 29th August 2011, my lord, the modification of the prescribed qualification laid down by NCTE. Lord, kindly, my lord, turns over the page. Lord, kindly comes to, my lord, this date. This is very important. 8th of November 2010. Lord, excellent. Lord, the Ministry of Human Resource Development, Department of School Education, Government of India permitted the state governments to seek relaxation of minimum qualification for appointment of primary teachers. Lord, kindly permit me to read the next few lines which are in bold. However, by the said notification, it was specifically intimated that condition of passing TET will not be relaxed. Lord, my lord would very kindly find Lord, this notification at page 8 of Lord, the compilation which I've handed up to my lord, the list of dates.
Yeah.
Now, my lord kindly sees this is 8th November 2010. Lord, the National Council of Teachers Education has in exercise of powers under so and so laid down the minimum qualification for persons to be eligible for appointment as teachers in school with a notification number 23rd August so and so and 25th August 2010. The notification has already been circulated to the state government and authorities. The notification can also be downloaded. Accordingly, all appointments of teachers in class 1 to 8 in respect of all schools referred to in so and so have to be made in accordance with the said notification. And then see, subsection 2 of so and so act provides that where a state does not have adequate teacher education institution offering courses or training in teacher education or teachers possessing minimum qualification as laid down in subsection 1 of 23 are not available in sufficient numbers, the central government by notification may relax the minimum qualification. So it is only, my lord, the minimum academic qualification which, my lord, the central government, my lord, has a power, my lord, to relax. Required to appoint as a teacher for such period not exceeding 5 years as may be specified. And then Lord, kindly turn over the page. Lord, kindly see serial number 4. The condition of passing TET will not be relaxed by the central government. Now, my lord, getting back, my lord, to the facts of the instant case. My lord, the case made out is 2011 My lord, the case of the petitioners is that they have been appointed from 2011 to 2017. My lord, I presume that when they make this, my lord, averment, my lord, in that event, my lord, they all are TET pass candidates, and hence, my lord, they have been appointed between 2011 and 2017.
Yes.
Now, my lord, kindly see, my lord, I shall show to my lord, that all these petitioners who have been, my lord, appointed, my lord, they claim to be appointed during 2011 to 2017, have, my lord, passed the TET examination either in 2022 or in 2023. Lord, kindly take note of the pages, my lord. I need not trouble my lord with all the pages of the writ petition. The page numbers where the petitioners' TET certificates of 2022 would be available are pages 110, 122, 126, 130, 134, 138, 142. So, my lord, as in 2011 or, my lord, until 2017, my lord, these petitioners, my lord, did not have the TET qualified, my lord, certificate.
Yes.
And my lord, in the teeth of the notification, my lord, dated 8th November 2010, which I just showed to my lord, they could not, my lord, have been appointed. This appointment, my lord, either, my lord, is illegal or, my lord, it's fraudulent.
Yes.
Now, my lord, Javeer Singh, my lord, has been placed before my lord. My lord, Javeer Singh, my lord, only created a one-time window for in-service candidates. But the presumption of such in-service candidates is that only, my lord, those candidates who have lawfully gained employment, my lord, upon fulfillment of all requisite qualification.
As per 23rd August 2010.
I'm grateful. My lord, I'm sorry.
Yes.
Because, my lord, 8th November 2010, it says that all appointments, my lord, must be given only to TET pass candidates. So a candidate, my lord, who was not a TET pass candidate could not have been appointed. And, my lord, such, my lord, candidates were not given the one-time protection of, my lord, being permitted to join the 18 months DLIT course.
But then how could these persons get admission to DLED course?
My lord, why? My lord, these, my lord, applications, my lord, were on, my lord, on online mode. My lord, they said that they are in-service candidates. My lord, the documents, the testimonials, my lord, were not verified properly. So they were treated on their misrepresentation. Today we question, my lord, as to whether they can reap the fruits of such misrepresentation and deceit.
Yes.
And my lord, kindly, my lord, takes up, my lord, my lord, list of dates. My lord, kindly sees, lord, the next page, page 3, my lord, will find a date, 1st April 2015. The central government, by a further notification dated 1st April 2015, extended the said relaxation for state of West Bengal till 30th of March 2016, and further clarified that the person having senior secondary or equivalent with at least 50% marks are also eligible for TET for class 1 to 5. But the purpose of showing this document is relaxation, whatever is being given, my lord, to the academic qualification. TET, my lord, requirement has not been dispensed with at any stage by NCTE.
Yes.
Or, my lord, in Javeer Singh or in Kaushik Das. Lord, kindly, my lord, takes up Lord Javeer Singh for a moment. And before that, my lord, I must say, Lord, that 30th of May 2025, Lord, which is, Lord, at page 65, Lord, was challenged before the Honorable Supreme Court by filing, Lord, an IA application. Lord, that challenge, Lord, was withdrawn. Lord, I understand Mr. Sanyal has shown that. Now, it was also, my lord, construed by the petitioners that this imposition of a cutoff date for a candidate to have qualified the TET examination is also violative of the order passed in Kaushik Das. So contempt application was also filed. Well, the contempt application was also dismissed. Lord, this, Lord, was the order passed, Lord, in the contempt application. আমার কাছে আছে। I mean, I'm sorry.
Yes.
Lord, my understanding is, Lord, that a person aggrieved, Lord, will have, Lord, a locus to challenge 30th of May 2025 before my Lord's court. Lord, in the prayers, Lord, I do not find, Lord, that any express challenge has been thrown to the propriety of 30th of May 2025.
Yes.
My Lord kindly sees that this 30th of May 2025 was issued by the board in its own understanding of the effect of Jaivir Singh and Kaushik Das. This executive order till it remains in the file of the authority who is conducting the process of selection. Till it remains on the file, it has to be adhered to, and that is the understanding which would emanate to all eligible candidates who participate. They would know that this is a criteria. So dispensing with the requirement of whatever is there in the memo dated 30th of May 2025, the board cannot permit the petitioners by dispensing with the requirement of TET pass candidate certificate on or before 10th of August 2017. This requirement cannot be dispensed with. Kindly sees Jaivir Singh for a moment. My lord has been handed over SCC online copy.
No, this is a.
No, I hand up.
Not SCC online.
Oh.
Jaivir Singh.
हाँ Jaivir Singh. এটা দিন, এটা ফ্ল্যাশ কপি, এটা দিন। কেন এই ফাঁকে লেগে গেলে পরে? Well, the scope of Jaivir Singh has been placed before my lord. I would invite my lord directly to paragraph 32.
Yes.
তো কই গেল? কোনটা? এই 23-এর পরে 35 চলে আসছে। না 34 থেকে এগুলো আমার কাছে নেই তো। Lord kindly sees, as discussed herein above, the second provision to subsection 2 of 23 RTE was inserted by the 2017 amendment 32. However, with retrospective effect from 1st April 2015, as such the teachers who were appointed or in position as on 31st March 2015 were required to acquire the required qualification within a period of 4 years from date, that is 1st April 2015. The communication dated 3rd August 2017, the 3rd August 2017 is not referred, addressed to the additional secretary will clarify the position. Then 3rd August 2017 is already placed. I am not repeating. It is thus clear that all the teachers working in either government aided, unaided private schools were required to acquire minimum qualification or they would face dismissal from service. It appears that it was decided by the central government to provide a window for all such teachers. Lord, I pause here for a moment. So, my lord, this one-time window was given only to those who did not subserve the qualification criteria, that they should not attain the requisite qualification. A perusal of the said communication would reveal that various directions were issued so that lakhs of teachers who were untrained get the requisite qualification prior to 1st April 2019. The communication addressed by the director to the Chief Education Officer and the District Education Officer Uttarakhand would further clarify this position. It appears that in furtherance of the direction issued by the so-and-so, recognition order on 22nd November 2017 was issued. It will be relevant to refer the preamble. Lord, kindly sees the second paragraph. The first paragraph, the matter of recognition of the project proposal of NIOS program through so-and-so for training of in-service untrained teachers was considered over several years. And whereas NCTE has received directions under the so-and-so act, the letter proposal, the project proposal of recognition of DLAD program through ODL mode has been submitted by the National Institute of Open Schooling to NCTE headquarters. The proposal is for conducting online so-and-so as per number the first appendix. As per the NCTE notification dated 23rd August 2010 and 29th July 2011, one of the minimum qualifications of appointment of teachers for class 1 to 5 and 6 to 8 is 2 years DLED. As per NCTE order dated 22nd September 2017, program of NIOS is only for those untrained in-service teachers in government aided, unaided appointed on or before 10th August 2017. So in service as on 10th August 2017 presumes that he has fulfilled all the other qualification in terms of 8th of November 2010, more particularly with regard to the TET qualification, which has not been dispensed with ever since 23rd August 2010 came into being, prescribing for the qualification essential for appointment of a primary teacher.
Yes.
But this was, my lord, the issue before the Honorable Supreme Court. Now kindly sees that paragraph 39. It is thus clear that the entire scheme was for the purpose of providing a window to the in-service teacher in as much as unless they would have acquired requisite qualification on so and so, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that High Court has erred in holding 18-month diploma conducted by NIOS mode is equivalent to diploma provided in the notification stated. So it is not that this 18 months, Milord, was at any point of time, Milord, made as Milord an open offer to anyone who wants to undergo this training program. It was only, Milord, to ameliorate the Milord adversities faced by the in-service Milord teachers. And when I say in-service, Milord, then Milord, I presume that the Honorable Supreme Court, Milord, had duly taken cognizance of the fact that these in-service teachers are the appointees who have been appointed in accordance with the Milord prescriptions of 8th November 2010. Milord, kindly, Milord, comes to paragraph 49. We therefore find that the High Court has erred in directing the state government to consider the candidates who did not qualify as per the 2012 service rules. Milord, I pause here for a moment. Milord, in terms of this, Milord, the concerned state government, Milord, had framed rules. Milord, like in our case, Milord, the High Court, the Honorable Supreme Court, Milord, upheld, Milord, this and said that High Court erred in permitting those candidates who did not fulfill the qualification laid down in the 2012 rules. And as per advertisement based on the service rules, particularly when the 2012 rules and their advertisements were not under challenge. Number 3rd August 2017 is followed in the 30th September 2025 notification, both my lord lay down a cutoff date of 10th of August 2017. I say, my lord, neither 3rd August is under challenge, nor 30th of May 25 is under challenge.
3rd August you have annexed.
My lord, 3rd August, my lord, is here.
Yes, yes. 3rd August. Yes. 55.
My lord. My lord, kindly, my lord, comes to paragraph 52. In view of what has been held, I'm sorry.
Yes.
In view of what has been held by this court herein above, we find that the High Court erred in holding 18 months diploma conducted by NIOS through ODL mode is equal to 2 years regular diploma, particularly so when there was no material on record to even remotely hold that such a qualification was recommended by the expert body. On the contrary, the communication dated 6 September 2019 by NCT, the directors of MHRD, the recognition dated clearly goes to show that 18 months diploma was provided as a one-time window to the in-service teachers. And then paragraph 53, it again recognizes the authority of NCTE to lay down the guidelines, and the sacrosancy of such guidelines will not have been recognized in paragraph 53. That leaves us with reliance placed by the learned counsel for NCTE on the judgment of this court in Ramsaran Maurya. There can be no doubt that NCTE as an expert body has a right to prescribe the minimum qualification. In the present case itself, the notification dated 23rd August 2010, 29th July 2011, NCTE has done so. As already discussed, recognition order dated only provides a window for in-service teachers to complete the course. As such, the judgment does not apply to the present case. So, NCTE's authority in prescribing 23rd August or 29th July 2011 and the subsequent notifications have not been interfered with. If that be the case, then 8th November 2010, prescribing for TET examination qualification as essential for anyone to be appointed as a primary teacher, that stays. And in 2011 to 2017, these petitioners, none of them had this qualification. By admission, I have indicated the page numbers. These petitioners have gained the TET qualification not any time before the TET 2022 examination was held. The question is, as to whether these fruits of deceit and misrepresentation caused by the petitioner in misrepresenting themselves to be in-service candidates in gaining admission to the 18 months course, this can inure any benefit in equity to them or not. I rely on the decision (2017). 2017. This is reported in 2017. Ektu deben, please. 2017, volume 8, Supreme Court cases, page 670. Paragraph 56. Caste certificate fraudulently obtained by causing misrepresentation. That was a subject matter. The Honorable Supreme Court held, I shall show, that benefits reaped by such misrepresentation cannot be saved. Appointments cancelled, any other benefit reaped, that cannot be saved in equity, not even under Article 142 of the Constitution.
Paragraph 56.
Paragraph 56. That would be at page 724.
Yes.
Service under the union and the states, or for that matter, under the instrumentalities of states, subserves a public purpose. These services are instruments of governance. Where the state embarks upon public employment, it is under the mandate of Article 14 and 16 to follow the principles of equal opportunity. Affirmative action in our constitution is part of the quest for substantive equality. Available resources and opportunities provided in the form of public employment are in contemporary times short of demand and needs. Hence, the procedure for selection and the prescription of eligibility criteria has a significant public element in enabling the state to make a choice among competing claims. The selection of ineligible person is a manifestation of a systematic failure and has a deleterious effect on good governance. Firstly, selection of a person who is not eligible allows someone who is ineligible to gain access to scarce public resources. Secondly, the right of eligible persons are violated since a person who is not eligible for the post is selected. Thirdly, an illegality is perpetrated by bestowing benefits upon an impostor undeservingly. Lord, kindly, Lord, comes to paragraph 65. Lord, may I?
Yes.
Administrative circulars and government resolutions are subservient to the legislative mandate and cannot be contrary either to the constitutional norms or to the statutory principles. Today, my lord, when I indicate to my lord, 8th November 2010, and then, my lord, I indicate my lord, 3rd August 2017, and then I indicate to my lord 30th of May 2025, my lord, I say that all these, my lord, are in, my lord, one consonance. My lord, TET, my lord, has been held to be, my lord, mandatory in nature, and then to those candidates who say that I am in service and I want to avail of the one-time window, Lord, on the date when NCT is issuing a circular, it is saying that today, if you say that you are in service, I am fixing a date of 1 month hence, you would be presumed to be in service on that day. That window is open for you. And there, my lord, is, Lord, the mandate of the requirement of the TET pass qualification. So this cutoff date, my lord, has a significance.
Yes.
Lord, kindly sees, my lord, paragraph 66. One of the considerations which is placed in store before the court, particularly when an admission to an educational institution is sought to be cancelled upon invalidation of a caste or tribe claim, is that the student has substantially progressed in the course of studies, and cancellation of admission would result in prejudice not only to the student but to the system as well. When the student has completed the degree or diploma, a submission against its withdrawal is urged a fortiori. In our view, the state legislature has made a statutory decision among competing claims based on a public policy perspective, which the court must respect. The argument that there is a loss of productive societal resources when an educational qualification is withdrawn or student is compelled to leave the course of studies cannot possibly outweigh or nullify the legislative mandate contained in so and so. Lord, kindly skip over, Lord, the next line. Lord, kindly comes to the line starting with the words, when a candidate is found to have put forth a false claim.
Yes.
My lord has very kindly got it.
Yes.
Of belonging to a designated class, tribe, or class whom a benefit is reserved, it would be a negation of rule of law to exercise the jurisdiction under Article 142 to protect that individual. Societal good lies in ensuring probity. That is the only manner in which sanctity of the system can be preserved. The legal system cannot be seen as an avenue to support those who make untrue claims to belong to a class, caste, tribe, or societal educationally backward classes. These benefits are provided only to designated so and so. Lord, I pause here for a moment. I draw an analogy. Lord, fruits of misrepresentation and deceit. Lord, in the case before, Lord, cited, this is in respect of, Lord, caste certificate, Lord, being falsely obtained, benefit being reaped. The Honorable Supreme Court said, even in invocation of Article 142, we would not save this. Today, Lord, there are petitioners before my Lord who say that we are in-service candidates. This, my lord, in-service status is a misrepresentation, is a result, my lord, of fraud and deceit. That is where, my lord, I draw an analogy and say that this status or the benefits, my lord, caused by such misrepresentation, my lord, cannot be, my lord, saved. My lord, only, my lord, one more paragraph, my lord, which is paragraph 73. Sorry. During the pendency of litigation, the respondent is retired from service and has even paid his terminal dues. Hence, at this stage, all that can be observed is no claim by a member of so-and-so caste can be observed, is that no claim by a member of so-and-so caste shall be made or entertained on behalf of the respondent, any member of his family, on the strength of caste certificate which has been invalidated by the scrutiny committee. So, my lord, the fruits of fraud have been permitted not to be reaped. And this, my lord, is a decision in rem for the entire community. If my lord today holds that those candidates between 11 to 17 who did not possess the TET pass certificate and yet represented themselves to be in-service candidates in gaining fraudulent, my lord, admission to the 18 months course, my lord, I say, my lord, in rem, my lord, they should be, my lord, penalized in a like manner, would not be, my lord, permitted to reap the benefits of such fraud and misrepresentation. भाई होते पिटिशन है तुम्हारा सब्स्टेंटिव क्लियर होते पाएगा ना Lord, just one more decision, my lord, I cite. Lord, this is, my lord, reported in 2016, volume 4, Supreme Court cases, page 791. For fraudulently securing benefits, my lord, under the Disabilities Act, my lord, Ramchandra Singh, my lord, 2003 Supreme Court, my lord, was relied upon, my lord, in paragraph 8. My lord, and fraud and its implication, my lord, has been spelt out relying on Ramchandra Singh. Fraud, as is well known, vitiates every solemn act. Fraud and justice never dwell together. Then, my lord, kindly sees that 17, subparagraph 17 of paragraph 8, it is also well settled that misrepresentation itself amounts to fraud. And then 18, a fraudulent misrepresentation is called deceit and consists in leading a man into damage by willfully or recklessly causing him to believe and act on falsehood. This is what the petitioners did when they declared themselves falsely to be in-service candidates. And then 23, an act of fraud on court is always viewed seriously. A collusion or conspiracy with a view to deprive the rights of others in relation to a... Lord, this is not relevant. I'm sorry. Lord, I beseech your lordships, but very humbly, that Lord, the petitioners before my lord, Lord, they were not eligible to, my lord, secure admission in the 18 months course, which has been held not to be equivalent to the 2 years DLAD. And they, my lord, cannot derive any benefit in respect thereof. The writ petition should be dismissed.
Mr. Dasgupta, those two matters 256 and 257, I am passing a single order, making it with, because at that point of time I was of the notion that one of the matters with 22 and 23 and rest was with but I find that they are similarly circumstanced or passing a single order.
One single.
Yes, with, sure, yeah. Oh. Yes, Mr. Chatterjee.
I need some time. Can I come back tomorrow?
When? Not tomorrow. After the vacation, I'll take it up.
There, any day
After the vacation, we'll do it. In the first week itself, I'll take it up.
kindly fix a date.
Yes. Affidavit of service, Mr. Chaturvedi. Can 1 of 2025. This is an application for affidavit of service filed on behalf of the petition is taken on record. This is an application for
Milord, I have a letter, Milord, I shall affirm in course of the day and will not file it.
Mr. Chaturvedi, learned senior advocate appearing for the petitioner, undertakes to file the affidavit of service. This is an application for addition of party. The petitioners contain that they are. Which paragraph? You have filled your form or you are aspiring to participate in the ongoing process? What is-
Yes,
We have filled our form. Milord, paragraph 4.
your paragraph.
Paragraph 4, supported by the annexures in P1 collectively.
The petitioners not four,
Milord,
not
paragraph 35 of my application, I have stated
25.
35, 35. And the documents are at page 76 onwards.
They are candidates who have applied for participating in the ongoing recruitment process with a notification dated 25th September 2025, number 35 in Yenavan. Read with notification number such and such dated 19th November 2025. They seek for impleading them as a added respondent. Mr. Chaturvedi, Piyush Chaturvedi, learned senior advocate appearing for the applicant, submits that the rights of the petitioners are very much will be affected by the prayers made by the petitioners, and as such they are necessary party to be impleaded in the present proceedings. Mr. Sobhusachi Chatterjee, on the contrary, Mr. Sobhusachi Chatterjee, learned advocate for the opposite parties, respondents, opposite parties, submit that the petitioners are no way, the applicants are no way affected by the prayer made by the petitioners, and therefore their prayers should not be allowed. Para, it is not in dispute that the petitioners are applicants in the ongoing process of recruitment initiated by the West Bengal Board of Primary Education pertaining to notification dated 25th September 2025. Thus, this court finds that the applicants are necessary parties. Accordingly, the applicants are added as
8 to 11.
Respondents numbers 8 to 11 in the present proceeding. 8 to 11 in the present proceedings. Can 1 of 2025 is accordingly disposed of. The name of the applicants be added in the array of the writ petition, array of the respondents in the cause title of the writ petition. Writ petition heard Mr.
No. Amended cost title maybe.
Amended cost title, I'll provide them.
Learned advocate for the advocate on record for the petition is directed to serve a copy of the amended cause title to the learned advocate for the respondents. WP heard Mr. Sobhusachi Chatterjee, learned advocate for the petitioner, who concludes his argument. Mr. Subir Sanna, learned advocate for the board, also concludes his argument. Next argument is also concluded on behalf of the added respondent number 8 to 11. Mr. Chatterjee, learned advocate for the petitioner, seeks accommodation to place his replies. Is this matter? Date bol? January প্রথমের দিকে বলুন। 9th 9 January.
Lord, arguments are concluded. Arguments are concluded by the respective parties. Will it be my lord's pleasure to keep it as a matter heard in part? Because my lord has heard everyone. I don't think Mr. Chatterjee would object.
Nothing will change.
Lord, item number 600. Lord, item number 606 will be taken up tomorrow at the top.
Don't know.
There is urgency, my lord. 1 marks is only required, my lord, pursuant to the expert committee report. On last occasion, Mr. Sannal took time, my lord. Your lordship fixed it today.
What to do?
Item
Nothing will happen.
It's a very urgent matter, my lord. If my lord kindly fix it tomorrow, my lord.
My lord, last
My
date
lord,
is
item number 608, my lord.
my lord, item number 606 on last occasion, my lord, the board took.
My lord,
Kindly take it up tomorrow, my lord. It is
my lord,
extremely urgent.
608, my lord has fixed today, my lord. If my lord kindly keeps it tomorrow, my lord.
Not tomorrow. Why
Then,
not?
my lord, on Wednesday, then,
My
my
lord,
lord, on
kindly, my lord. My
Wednesday,
lord,
your
it's very
lordship will be
urgent,
taking.
my lord.
Your
It's
lordship
very
will be
urgent, my
taking.
lord.
The first half there is mentioning, in the second half after 4:30 there is mention.
There is extreme.
My extreme,
Urgency after the vacation I'll fix date to clear out the matter.
my lord, extreme urgency, my lord. The matter is pending for over 2 years, my lord.
MSc appeal to now.
My lord, kindly.
My lord, kindly, my lord.
Kindly take it up day after.
My lord,
Day after tomorrow not possible.
my lord, tomorrow,
Last occasion,
tomorrow, my
took
lord.
time, my lord.
Day after
My lord, last
Heard
occasion.
you, I have heard you.
My lord,
Nothing will happen, going to happen in 7 and 10 days.
My lord, my lord, they will start the appointment process, my lord.
Start, my lord.
I
My lord,
tell
will be
your lordship,
prejudiced.
my lord, my lord, I tell your lordship, I mention the matter before your lordship, considering the urgency, your lordship fixed the matter last Monday. Your lordship took up the matter.
What to
Mr.
do,
Shan
sir? What
paid
to
for
do?
an adjournment.
We can at least try, no?
My lord, in the meantime, they will start appointment, my lord. This is the.
My lord, the petitioners will be prejudiced, my lord.
Sir, we have already applied. Already applied, my lord. My matter will not take.
Yes.
One.
My lord, my matter will not take much time.
The matter needs to. No, this is for stay and condemnation delay of 10 days. I have already deposited the 25,000.
Where is the service?
But it is the first day.
Where is the service of the copy?
No, I have not served. The first day, we have to
Serve
get
the
a
copy of the Section 5 application.
Section 5.
Section 5 we have sent.
No. Initial will not 10 days delay, and also we have deposited 25,000 statutory deposit we have made. So, as usual, order will not stay, and we will deposit the balance amount within certain period, and we will serve the copy on the.
Which is Section 5 application?
Yes, can 2.
Can 2 of 2025. This is an application for condonation of delay in preferring the appeal. And advocate for the applicant, sorry, appellant. Appellant applicant is directed to serve copy of the application for condonation of delay upon the respondents and file affidavit of service on the returnable date. Can 1 of 2025. This is an application for stay of can 1 is stay of operation of impugned judgment and award dated 5th March 2025 passed by MSc Tribunal Fast Track Court, Baharampur, Murshidabad in MACC case number 74 of 2008. Mr. Toibalundi Bhomik, learned advocate for the appellant insurance company, submits that the appellant has already deposited the statutory amount of rupees 25,000 and is willing to deposit the entire awarded sum together with interest.
Yes.
He seeks for, on such score, he seeks for stay of operation of the impugned judgment and award of the learned tribunal. বাকি তো ওখানে দেখে নেবো না? It is found that there is found from the report of the computer section appellate side High Court Calcutta that no caveat has been lodged. What are you giving?
The receipt of the 25,000.
Give that. As per the office note dated 4th September 2025, it is found that statutory deposit of rupees 25,000 as per section 173 of the Motor Vehicles Act has been deposited by the appellant insurance company. The challan receipt video challan OD challan number 335 within bracket A dated 10th June 2025. Photocopy of challan is also submitted by the learned advocate for the appellant insurance company. View of the above, there shall be stayed for a period of 4 weeks. Appellant is directed, appellant insurance company directed to deposit the entire awarded sum together with interest before the learned Registrar General High Court Calcutta within a period of 4 weeks from date. In the event such amount is deposited, there shall be stay of operation of the impugned order till the for a period of 4 weeks. Failing which, the stay shall stand automatically vacated. Learned advocate for the petitioner is directed to serve copy of this application upon the respondent file affidavit of service on the returnable date. List this matter after 3 weeks of ensuing winter vacation before the regular bench having determination. Okay.
Next item, my lord, is 10:30 fixed. Your lordship fix the matter. Next matter, 10:30 also. It will appear tomorrow, my lord.
Second item, second is the interim order.
Extension of interim order, my lord.
Side is here.
Which item?
Under the second matter, my lord. I am for the
Tomorrow will
DPS.
extension में काल के दिए दो.
अच्छा.